Yes, Mr. Singh.
No, please, the court. I have tried to refine and order the submissions in a way which I hope will be as helpful and as efficient as possible. Can I first of all give the court the outline of how I propose to do this? I'm going to do ground one because clearly that is the major point and issue. Then, if it's convenient for the court, I'd like to skip over to ground three, which is also a point of principle, and then ground four, likewise, although that's quite a short point, and only then to go back to the fact-specific matters in respect of which there are some fact-specific applications and so on.
Well, that's fine, and you must do it in the order that you think appropriate, but I think we should just flag up that if ground two is made out on the facts of this case, it might be said that everything else is academic, and generally speaking for myself, I don't like deciding academic points.
Lord, yes, I can see that. The nub of the case on ground two is that the judge was well aware that to satisfy the Kadir test, there had to be some prospect of removal. One of the things that I will show the court, I was planning to do that as part of the historical or chronological approach that I was going to take to ground one, is just what that means, or what that was thought to mean in the factual context in Kadir. You don't have to have very much in order to be some prospect. The judge was fully aware of that, and she dismissed the application for judicial review. So it must have been her view that there was some prospect of removal. The real complaint, as we analyse it, is that the judge didn't express herself very clearly and didn't say very much about this. Now, we say that that's explicable because although the claimant was entitled to advance the point about whether there was some prospect or no prospect.
Well, Mr. Singh, I'm sorry to interrupt you. I don't want to take you out of order. You present the submissions in the order you think appropriate, but I flagged up the concern I have.
Lord, yes, I'm grateful, and I've really, I think, taken my cue from the court's indication yesterday that it will be helpful to hear all of the submissions.
Yes.
And if the court is going to, or is likely to address all the points of principle, then it will, I think, be logical if I do the points of principle first.
All right.
The subject matter of ground one is, as we know, what is Schedule 10 of the 2016 Act, which is the provision now in force. As by way of introduction, can I just ask the court please to turn that up? It's Authorities tab 3, which is page 9. So far as the Secretary of State bail is concerned, the key parts are really paragraphs 1.1 and 1.2.
Yes.
And we can entirely see that if there was no history and all we had was a decision of the Court of Appeal and then the Supreme Court in B. Algeria, that the appellant's arguments on this might have some force. But there are two things which we say require addressing. The first is the phrase, the person is liable to detention, because that does have considerable legal history. And the second is the provision in paragraph 1.5, which would be meaningless if the appellant is right. So the key questions for the court, we say, are what do paragraphs 1.2 and 1.5 mean? And that is something which is enormously informed by the legal history behind these provisions. I will return to the detail of all of that in due course, but I wanted to set that out at the outset because that is what we need to focus on, the question of how does a history affect the way that these two provisions are to be read. In my oral submissions, I'm hoping not to just repeat or parrot things which are in the skeleton argument, and you have the detail there, but rather to focus more on the things that were put against us in oral argument yesterday. but also to show you the historical context and approach, which we say is the appropriate one to addressing these questions. Then that's why what I propose to do is to address this in chronological order, going through all the various stages that have led us to the provisions in Schedule 10. The starting point, though, if I'm going to do it chronologically, is what I might call the ancient history. It is a fundamental part of the appellant submissions and also bids that bail has had a single fixed and unvarying meaning down the centuries. And we respectfully say that that is not a correct proposition, and therefore it's not right to import that approach into the construction of Schedule 10. That even at common law, the term bail has had different meanings over the centuries. And it is therefore clear, we say, that if Parliament is legislating, which it has done, it can properly set up a new system which really needs to be looked at on its own terms, rather than by saying, oh, because the word bail was used, therefore you must import all of these old concepts. The first point to make is that back in the day, the word bail was used to describe something rather different from the way we now use it. The best place to pick this up is in the tab 72 of the authorities, which I suspect is probably in your volume 3. And this is starting at page 1941. It's Highmore's Digest of the Doctrine of Bail. You'll see the date of this publication at the bottom of 1941. The year is 1783. And if you go over the page to 1942, the derivation of the word bail, given by Cook in his Fourth Institute, is from the French noun bail, a guardian, keeper, or jailer. And then on the right-hand side, 1943, by about 5 lines in, a derivation similar to this we find in the terms delay, where it is added that the person bailed is delivered, as it were, into the custody of his bail, to be forthcoming at a certain day, and is therefore said to be a surety of body for body for an appearance. So that was what bail was, somebody was delivered into the custody of somebody else. In a sense, we've described this elsewhere as custody by proxy. So instead of being in state custody in prison, you're in the custody of somebody else. You're the person who's surety for your bail, in the sense that it was then being used, probably in rather more congenial conditions than there would have been in prison.
Yes, here we're dealing with persons, but presumably, as a matter of law, things could be in the charge of a bailee. For example, one's aware of that.
Yes, of course.
That's probably a cognate use of the phrase.
Yes, we haven't done that part of the research to find out how it relates to the concept of bailment of goods, but you do see the same concept there in play. For our purposes, the important thing is the difference between bail and a concept of main prize, a word which has now fallen out of disuse, and you see that at 1946. Main prize, manufactio, word, signifies taking a man into friendly custody who might otherwise be committed to prison on security given for his appearance at a time and place assigned, and is supposed to go at large without any fear of being taken by his manufacturers to secure themselves, as in cases of bail. So clearly there's a distinction there. He says further that manufacturers are only sureties, that in case a criminal does not appear, though he is arrested or in prison, they are to forfeit their recognizance. Bacon confirms this definition in the following words, which he takes from the authorities there cited. Main prize is that the main perners are barely his sureties, and cannot imprison him themselves to secure his appearance, as his bail may, who are looked upon as his jailers to whose custody he is committed. And then skipping down to the section, the difference between bail and main prize, the difference consists in this, that he that is main prize is always said to be at large and to go at his own liberty out of ward after he is put to main prize until the day of his appearance, by reason of common summons or otherwise. But it is not so where a man is put to bail by 4 or 2 men, by my Lord Chief Justice and heir of the forest until a certain day, for there he is always accounted by the law to be in their ward and custody for the time, and they may, if they will, hold him in ward or in prison till that time, or otherwise at their will, so that he who is bailed shall not be said by the law to be at large or at his own liberty. And then there's another quotation from Cook. But you see there very clearly the difference between bail and main prize, or mancatio.
Yes, Cook says that every bail is a main prize, but not every main prize is a bail.
That's right, yes. And so just from that old text, we can see that the modern concept of bail is much closer to main prize than the old bail. And in the mid-1940s, I think this was, or maybe 1950s, Professor Holdsworth, sorry, I'm going over to tab 73 now. Professor Holdsworth's History of English Law touched on this at page, now the page in our bundle is 1951, but the page number you can actually see is 4015. It's being reprinted from a Supreme Court bundle.
Yes, right.
Changes which are made for the greater efficiency of the law, and he says these changes affected laws to bail. It may be that in the early days, those who offered themselves as security for the appearance of an accused person were literally bound body for body. But in the 13th century, these sureties were only liable to amercement if they allowed their prisoners to escape. Later it became usual either to make the surety promise by recognizance to pay a sum certain in the event of non-production of the prisoner, or combining the older idea of the nature of the surety's obligation with the newer means taken to enforce it, both to make him promise by recognizance to pay a sum certain in the event of his non-production and to commit the accused to the surety's custody. If the accused was thus committed to the custody of the surety, he was strictly and technically his bail. So there you see the literal custody. If the surety merely gave security for his appearance, he was said to give main prize and to be a main perner. And we can see from the original Highmore text that is a pretty accurate description. And then if you go over to the next tab, there is a report of a Home Office working party. Can I draw attention to the date of this? It's 1974. You see on the first page again, the visible number is 4018. This was part of the work that led to the Bail Act 1976, with which we're all familiar. And you can see on the next page, at paragraph 10, there's a reference in the middle of that paragraph to the distinction between bail and main prize. And the last two sentences of that paragraph, a person admitted to main prize was not considered still to be in custody, and the main perners could not discharge their responsibilities by seizing the principal and returning him to custody. However, the distinction between bail and main prize later became blurred. And then over the page, paragraphs 106 and 107, don't think I need to read 106, but 107, the concept of the principal being in the physical custody of his sureties is no longer appropriate in present-day conditions, and in practice, sureties are rarely expected to exercise any degree of physical control over the principal. And so you see that the stepping stones to what we now know as bail. But even through the development of the common law, the terminology has changed, and so the old concept of bail is not one which is apt now for present conditions. There are two reasons for doing that. One is the point I've made already, which is clearly if even the common law can adapt so that the terminology changes, there's no reason why Parliament can't set up a system that doesn't immediately import all the old concepts that, of bail equaling custody, things that simply moved on from there. But the second is that in B. Algeria, this court was much influenced by an old case that referred to the old concept of bail, and that was Mitchell and Mitcham. It's tab 18, page 245. Very short report, as was then traditional. You see that the head note referred to the defendant being sued by complaint in Borough Court of Newcastle, and after appearance entered, took out a habeas corpus cum causa. That's the first thing to draw attention to. There was a writ that started with the words habeas corpus, but it was not the writ that we now know as habeas corpus. Our habeas corpus today is habeas corpus ad subjiciendum. And it is habeas corpus cum causa was a different writ. So the first point, habeas corpus, but not as we know it. And then the question for the court, you see in the second half of that paragraph, whether a writ of habeas corpus cum causa would lie to remove proceedings from an inferior jurisdiction into this court, unless the process was by capias or other proceedings against the body of the party. It was conceded that in this case proceedings were only by plaint, which required no more than a common appearance. And the over the page is the court's decision. The holding was this is not a case in which the habeas corpus cum causa will lie. It means that the sentence relied on is actually technically obiter, the penultimate sentence of that paragraph. The reasoning is because the proceeding was by plaint and not by process against the body, habeas corpus couldn't issue. And then the sentence which was then cited to the Court of Appeal and accepted was when common bail is filed, still the party in the eye of the law is in custody, and in such case the habeas corpus may issue. So not only is that technically obiter, but the reference to bail is as likely as not to be a reference to the old concept of bail in distinction to main prize, because there you see, in the eye of the law, is in custody. It will probably take a legal historian some time to work out exactly whether or not that's true, but you see the flavour of that. It makes this sentence unreliable, at the very least, as an indicator of what our modern bail is said to mean. So the 2 points from this is that really it's not habeas corpus as we know it, and probably it's not bail as we know it. And with respect to the constitution of this court in B. Algeria, it was really not of any great help. By the end of that, I should have said that case was 1823. By the end of the 19th century, linguistically, things had already moved on. And you get this from a Privy Council decision in Yusuf ud-Din, which is in the third volume at tab 71. Sorry, I assumed that it would be in the third volume.
Just give us a moment.
Sorry, which tab?
Tab 71.
Yusuf ud-Din.
Yusuf ud-Din. Yeah. Now, again, we've got a copying problem. Can I use the law report page numbers? Fourth sheet of the report with page 156 in the printed report.
Yes.
The question in this case, said Lord Macnaghten, the question in this case is a very short one. Is a prisoner who has been released on bail under imprisonment released on bail under imprisonment still, so long as he is out on bail? So very pithily stated.
Yes.
And the reason why it was important, you see from the chronology, in September 1895, the the 18th of September, a warrant was issued for his arrest. That's 4 lines down into the facts.
Yes.
About 8 lines up from the bottom, it was the appellant was arrested on the 28th of November. And then 2 days later, he was released on bail by the court. And then over the page onto 157, at the end of the first paragraph, the warrant was cancelled in September, on the 18th of September. 3rd of August 1897, the warrant was cancelled. And then 11 months later, July 1898, the appellant filed his plaint. And the question was one of limitation. And the limitation period you see at the top of the next page, if the imprisonment ended on the 30th of November 1895, that's a date of bail, the suit was time barred for the period of imprisonment. Period of limitation suit for false imprisonment is 1 year from the termination of the imprisonment. But their contention was that the imprisonment continued until the warrant was set aside, so long as the restraint of bail lasted, and it be taken that it lasted until the warrant was set aside. The appellant, they said, was not a free man. He was even liable to be actually imprisoned through the action of his surety or possibly by reason of the intervention of the government. So you see an argument there being put in similar terms to the appellant's today. But the Privy Council's decision was that nothing short, skipping over a few lines, nothing short of actual detention and complete loss of freedom will support an action for false imprisonment. And then near the bottom of the page, in their Lordship's opinion, it is perfectly clear that the appellant's imprisonment did not last 1 moment after he was liberated on bail. The very object of granting bail was to relieve him from imprisonment. Immediately after his liberation, he might have brought a suit for false imprisonment. And so for that reason, the detention ended when he was granted bail, and he was then out of time for this. So by the end of the 19th century, this is the decision actually 1903, clearly bail is being regarded as something that liberates you from custody. So you cannot extrapolate principles from these old cases. Certainly you can't say bail equals detention or anything like it. And so I'll come back to the Algeria later, if I may, rather than turn it up twice. But we respectfully say that the constitution of this court shouldn't have relied on Mitchell and Mitchell as heavily as.
What's the state of the law today? I can well understand, in accordance with this authority, that a person on bail could not maintain an action for false imprisonment, for example, for damages, for the tort of false imprisonment. But are they able to apply for the writ of habeas corpus?
We respectfully say no. No, if you're released on immigration bail under Schedule 10, there's no habeas corpus.
Sorry. Don't go straight to immigration bail under Schedule 10, because that may be a different creature in law.
Yes.
I'm just talking about the general situation of where somebody is on bail. Might be police bail, might be some other form, it might be judicially ordered bail. But are they able to apply for a writ of habeas corpus as far as the principles say I shouldn't be on bail?
We would say, in general, no. I'm going to be careful to qualify that because, of course, there is the decision of the Supreme Court in Jallow, which
yes.
Which said that there might be conditions of bail that amount to an imprisonment that allow you to sue for false imprisonment, and if you can, then in theory, then it might be possible to get habeas corpus. Yes. I'm also a little diffident about this because one of the things we do know is that over the last 2 or 3 decades, the use of habeas corpus in this situation has really tailed off dramatically. Yes. And in fact, at the urging of this court, in the case it's not in the bundle, because judicial review has now become the preeminent way of challenging that. Yes. And that, in fact, that pre-echoes the next topic that I'm going to go on to. But we say, as a matter of generality, habeas corpus isn't appropriate for modern bail in the general sense, except possibly in some very specialised circumstances.
That depends upon the nature of the restrictions on the liberty, which are conditions of your bail.
Yes.
And you accept that conditions of bail can be so restrictive as to amount to imprisonment for a tort of false imprisonment.
Yes, I have to accept that because of
Yes.
Jallo. Yes.
And is it your submission that the ambit of the writ of habeas corpus is coextensive with the tort of false imprisonment? Or are they different? Or does it not matter?
I wouldn't like to bind myself, or more particularly my client, to an answer on that, particularly because the law of habeas corpus has not really developed to keep up with the modern remedies that are invoked when people have complaints.
It's not been got rid of, but it's becoming obsolescent.
Yes, I would respectfully agree with that, yes. It's now very rare to find a habeas corpus application.
Thank you.
I said it's a pre-echo because the next part of the history that I should deal with is the approach to detention in habeas corpus cases. And my learned friend cites Amand for that. It's in tab 19 of the authorities bundle. In outline, the claimant was a person who was called out from military service by the Netherlands, but he was actually in the UK at the time, and he didn't return after being given leave, and then he was arrested, and he brought an application for habeas corpus. And what happened then was that he was released on bail. I think he was released on bail quite quickly. But there was still an important question for the court. The question actually is easily seen from 259, just by the upper hole punch. The sole question for our determination is whether the applicant was at the time of his arrest a member of the Netherlands military forces. And on that question turned the question of whether his arrest had been lawful or not. Now, of course, one possible approach that the court might have taken was, well, you're now on bail, you're no longer in custody, and therefore a writ of habeas corpus in itself won't lie anymore. But that would have meant that the court was disempowered from considering what it clearly thought to be an important question. And that's why if you go back to page 257, you'll see the observation, 6 lines up from the bottom of the page. He is now on bail, but this makes no difference, and we have to deal with the application as if he were still detained in custody, because only on that legal fiction could the court really determine the issue within the context of a habeas corpus application.
As the Chief Justice used the phrase "as if,"
That's right.
which suggests not that he is to be treated as being.
Exactly so. A legal fiction was here being applied to make sure the court still retained jurisdiction. Again, the problem doesn't arise today, or shouldn't arise today, because we now have judicial review. And in judicial review, there simply aren't these problems, and the court can just deal with the question of legality without having to import a legal fiction. But that is we respectfully say, the obvious and simple answer to why that legal fiction was adopted. It was not.
Was this the writ of habeas corpus as we now know?
Yes, as I understand it, yes.
What's happened? It may not matter. What's happened to the other writ of cum causa?
They've turned into other things. There are habeas corpus cum causa has some relationship, I think, to the writs of certiorari, which of course has now then evolved again. There were other habeas corpus writs that have now become things like witness summonses and subpoenas,
yes,
and so on. So it's all developed.
Yes,
and it's only one of them that has survived into modern day as habeas corpus. We respectfully say that the same applies to the 4 extradition cases in the supplementary bundle. I'm not going to turn them up, but you'll see that in every case, habeas corpus was the proceeding, or the form of the legal proceedings, by which the legal issue in each case had to be decided. And if you take the view that once somebody's on bail, you can't apply for habeas corpus anymore, then the court is just disempowered from considering the question. So it's the same legal fiction being applied. And today, of course, in extradition, we now have a new system that doesn't involve legal fictions of that kind. But the one thing is that none of this establishes that bail equals custody in any modern sense.
But we're bound by the decision of this court in B. Algeria, and indeed the decision of the Supreme Court in that case.
On the ratio of the decision, yes. But we respectfully say that where a particular step was founded on a misreading of an old authority, that doesn't bind the court.
Is that right? Does that make it per incuria? Yeah, so you say it is per incuria?
Yes, if it was...
I'm just wondering if any of this matters, frankly.
Well,
I mean, it may do, and if it does, we'll have to decide it. But it just occurs to me, speaking only for myself, that the concept we have to construe in the present appeal is not bail. It's the phrase immigration bail.
Exactly. That is, in fact, precisely our point, that the court should not succumb to the siren voices urging you to bring into the modern day these old concepts and old dicta, which were said in very different circumstances about different legal concepts. They just have no relevance to what the court has to decide in this case. That was the point of doing it. As I say, the two overarching points about this part of the submission are that even within the common law, concepts like bail and habeas corpus, for that matter, have changed, and the terminology has changed so that our modern concepts were called something different back then. And secondly, if the concepts can change even within the common law, so also can Parliament change the concepts by legislation, and that's what it's done. And that's why we invite the court to look at the modern legislation without importing these old concepts.
I understand that submission. The fairly rapid historical survey you've shown us tends to indicate that bail always at common law meant releasing someone who was in custody, being released either into the custody of somebody else or subsequently being released.
Yes.
Is that something that you accept? That was inherent in the common law concept of bail, that you're releasing someone who has been arrested or is being detained?
I'm happy to accept that. And it wasn't just in the old law, but even in the 1971 Act, which is where I'm coming to next, you had to be actually detained before you could be released on bail. So it's there, even in the statute at that time.
But I think your submission is that's not true of immigration bail necessarily. So.
Correct. That's exactly so. Just reflecting for a moment on Lord Justice Singh's question about binding, whether any of this is binding. The Supreme Court, the reason why we've got Supreme Court page numbers on these documents is that these materials were before the Supreme Court in B. Algeria when the Supreme Court heard the case. But that court found it unnecessary to pronounce on whether or not any of this is right. So it was unnecessary for its decision. So that, I think, would cast some doubt as to whether or not these particular points are binding on this court. But certainly, we now have a new statutory structure, and that is what we need to focus on. Can I then turn to the 1971 Act? And the relevant version is what's in tab 11. I know we've seen it already, so I just want to...
Can we just take this quite slowly, if you don't mind? I had some questions about it.
Of course, yes.
Tab 11.
It's tab 11, and I hope that your tab 11 now starts with the unnumbered paragraphs, the sheet with paragraph 16.
It does. Yeah. Now, the first question I've got is at some point it would help me at least to know under what precise provision this appellant was made the subject of a restriction in 2011. Because I look, for example, at Schedule 3, Paragraph 2, which is page 221 in this version. And what we've been helpfully given there is the version of the 1971 Act as it was between the 12th of July 2016 and the 14th of January 2018. Now, that may be all we need. But certainly speaking for myself, given the rather, I may say so, unfortunate procedural history of this case, where I don't think the judge below, forgive me if I'm wrong, I don't think the judge below refers to any of this. I don't think she seems to have thought this man was on temporary admission or something like that.
So I can't now remember if she used those precise words. The Schedule 3, released by the Secretary of State in under Schedule 3 powers, has often been referred to, and certainly within the Home Office, as temporary release. So Schedule 2, temporary admission.
Well, it may not matter, and I don't want to get caught up in sort of the procedural archaeology. I'm only making the point that certainly reading the judge's judgment, I hadn't fully appreciated what became very clear yesterday morning, which is that this man had not been on bail throughout the relevant period. And what may be significant to the legal arguments is exactly what was the regime to which he was subject between the moment when he was released, because he was released on the 27th of January 2011, and well, now, frankly, I speaking for myself, I really want to know precisely what was his legal status at every moment in that time, because it may matter. And I think what you're going to go on to submit to us is that when we look at the legislative regime, and in particular the transitional provisions, what is clear is that what was intended was that somebody who had been the subject of a restriction regime should seamlessly move to what was now called immigration bail, subject to exactly the same conditions.
I can see my Lord's point exactly. What we will do, but we'll have to do this after the hearing if we may, is to put together all of the versions of Schedule 3 that were relevant and to check that the appellant was released under Schedule 3 powers and what was maintained on Schedule 3 powers all the way through until the 15th of January 2018 when,
that would be helpful. I think it is important that we bottom this out comprehensively, because I'm aware that in fact he was not initially released by the Secretary of State at all. It was a decision of the tribunal. I think it was the 21st of January 2011. And then he's physically released from detention 6 days later. And so presumably they were granting some form of bail. Yes. I don't know, but I think we really do need to bottom out precisely what was going on. And then the critical moment, I suspect you're going to submit, is when Schedule 10 comes into force, and what happened then.
Yes. My Lord, perhaps in defence of the learned judge, the case was brought before her on the basis of the continuing bail being unlawful. And that was why none of us, I think, really focused on the history.
Oh, yes, I wasn't criticising the judge. I hope I'm not criticising anyone, but I certainly wasn't criticising her. Yes. But we need to be absolutely accurate. And the chronology may matter because, as I think you're going to point out to us, it's critical to know exactly what was happening on the date when Schedule 10 comes into force.
Well, I hope we have already now provided you with that. I should have mentioned yesterday we provided the regulations which have the transitional provisions for the inception of Schedule 10.
Yes.
Can I suggest, if you still got it loose, that just goes into the back of tab 3. Tab 3 being Schedule 10 itself with the transitional provisions, and then the regulations will go and...
Yes, if you're going to that, but don't take this out of order, please. There's something rather curious about this document, which I've noticed, which is that there appear to have been two versions of this. One was enacted, but then almost immediately repealed, and then replaced with this one. I have no idea why it was thought necessary to do that. There seemed to be a slight difference in wording between the two versions, but I don't think it makes any difference to this case.
Okay. Again, may we put that on the research list,
please,
because I wasn't aware of that wrinkle.
Yeah. But is it, if I understood this correctly, that the critical date we need to focus on is the 15th of January 2018?
That's right.
And is that the date when the relevant provisions of Schedule 10 were brought into force?
That's right, yes.
Now, what do you want to show us next then?
Right. Can I go back to tab 11 and the 1971 Act? The points that I'm going to make, and so some of these are also of relevance to the other grounds. Well, I hope if I do this, I can avoid coming back unnecessarily. The language of the detention powers, so paragraph 16 basically setting out detention powers, is that a person, in each case defined, may be detained under the authority of, and here it's an immigration officer, and you see that in 1, 1A, 1B, etc. And that's the way the immigration legislation identifies detention authorities. Then going on to page 212, paragraph 21, I draw attention to the fact that the people to whom the power of temporary admission relates are a person liable to detention or detained. I draw attention to that because, in a sense, anybody who is detained, assuming that they're lawfully detained, is a person who is liable to detention. There's an OTO's repetition here that's then repeated, and we say that that's just one of these drafting things that happens. But that is where the important phrase liable to detention is found. And then if you skip on, please, to Schedule 3, which is page 221, you'll see a very similar structure there. There's detention powers in subparagraph 1, 2, and 3. And in particular, in 2 and 3, you see the formula detained under the authority of, in this case, the Secretary of State.
Sorry, where are we?
This is page 221, subparagraph 2, which is 3/4 of the way down the page. Where a notice has been given to a person that identifies the relevant people, he may be detained under the authority of the Secretary of State. Similarly for subparagraph 3, and then over the page on 5 and 6.
So forgive me, can we just go back to subparagraph 3 for a moment?
Yes.
Just to be absolutely clear about its structure, because yesterday we had some submissions about the final words, but I noticed overnight that actually the final words appear with a closing bracket. And therefore, have I got this right, that the structure of this provision is, where a deportation order is in force, he may be detained under the authority of the Secretary of State, pending his removal or departure from the United Kingdom. And one could, I think, stop there, but then there's a clarificatory provision. If already detained, then when the order is made, shall continue to be detained unless he is released on bail or the Secretary of State directs otherwise.
That's right. Yes. So the detention authority, prima facie detention authority, is the opening words. He may be detained under the authority of, and then the brackets simply identifies the, as it were, default position if the person is already detained.
Yes.
At the time that the deportation order is made.
All right. and then you were going to go on.
Yes, to subparagraphs 5 and 6 over the page.
Yes.
We see the structure again very similar to Schedule 2, because it is identifying, subparagraph 6 identifies the relevant people who are liable to be detained under the detention authorities above.
So this is the provision, is it, which gave the Secretary of State at the relevant date the power to impose restrictions on this appellant.
That's right.
But they could only be restrictions as to those specified matters.
That's right.
And for that purpose, he didn't have to be in detention. All that was required, the trigger condition was that he was a person liable to be detained under subparagraph 3 above.
Exactly.
So nevertheless, this is sometimes, as you said, I think, sometimes it's called temporary release, but that's not quite accurate, is that
It's
right?
not quite accurate. Right. We have also found that the term restriction order used in Home Office guidance, so when the learned friend uses that, that's correct.
Yes.
And of course the document itself you see in headed notice of restriction, but it's referring to these Schedule 3 powers.
So where's the document headed notice of restriction?
I think it's the core bundle right at the very back.
Yeah. Is that what we were showing yesterday?
What we were showing yesterday was a variation of conditions of bail, which is rather subsequent.
Yeah. That was a 2018 document, I think. I may be
Lords, I
wrong.
don't want to take Mr. Tam out of his train, but we do have what we think is the comprehensive documents that were issued through the period. There is within it a notice of restriction. I don't know if it's helpful to look at it now. I appreciate that.
What's the page reference?
It's not in the. This is not in the bundle. These are the additional documents that follow through the history of his release and on what terms that we've put together. And given that you indicated to Mr. Tam that you'd like to see them, I didn't hand them up to you now because we'd obviously better to have a comprehensive view of it. The Secretary of State is likely to have.
Let's decide.
But we do have an example of a notice of a restriction if you want to see it.
Well, what I'm going to suggest
Yes.
is that before we conclude this hearing, we agree what the parties are going to provide to us
Yes.
after the hearing.
It seemed to me to be the better approach, which is why I didn't stand up at the time when you were discussing
can I just
it.
finish?
But I think now it's only because you've said what does it look like, and I do have one in my hand.
Yeah,
I apologise that we haven't provided.
What I'm going to
this
suggest
before.
at the end of the hearing is that there should be an agreed note which gives us a comprehensive account of the chronology, both as a matter of fact and on what the relevant legal regimes were. And it may not matter, at the end of the day, it may not matter, but I certainly want to know precisely what was going on.
Yes, I mean, there is a submission that we want to make that is based upon the change from being on restrictions to bail, which we made yesterday. So we do accept, we will positively say it is important. But I appreciate that you want to do that when you've got the complete the factual matrix properly before you. And apologise that you haven't before now.
Thank you. Yes, Mr. Sam, sorry.
Look, I'm grateful. I was sure that there was notice of restriction somewhere in the bundle, but we'll sort that out.
All right.
And make sure you can see it. Going back to the law, the next point that I was going to go to was the bail powers, to show you some textual distinctions. First of all, back to Schedule 2, page 214.
Can I, just before you do that, when we were looking at Schedule 3, paragraph 2, is my understanding that your submission is the same as we received from the appellant, which is that Mr. Kaitey was released under the powers in paragraph 2, subparagraph 3, as somebody against whom a deportation order was in force, but the Secretary of State directed that he not be...
Well, I hope my Lord will forgive me for interrupting. That's what I'm not at all sure is actually accurate, and that's what I do want this to be explored fully.
And that's one of the things which I have in mind, that we should make sure that we do have correct. because the one thing which I think we can all be agreed on is that once the deportation order had been signed, the relevant detention authority was paragraph 2, subparagraph 3.
Yes, exactly.
And I think that we're all agreed that as from whatever date it was, 2011 or whatever, that the appellant was not in fact detained.
Yeah.
And it is the combination of those two facts that triggers the power in subparagraph 5, because the appellant was then somebody falling within subparagraph 6b.
Exactly. That's how I've understood your submission.
Yes.
And therefore it may not matter exactly how he came to be released from detention. What matters is the opening words of subparagraph 3, namely a deportation order is in force against him, he may be detained, right? Then you go to 5 and 6b, and you say that gives rise to the power to impose restrictions as per 5.
Exactly.
Sorry, where were you going next?
Back to the bail power in Schedule 2, which is page 214. The first point to draw attention to is that the condition that the people to whom this applies are people who are actually detained. And they may be released on bail. So there's no liable to detention language here. And that was regarded by the Supreme Court in Algeria as a significant difference. Can I just give you the paragraph number? It's paragraph 39.2. So that the Supreme Court thought that the Kadir principle didn't apply to this. And then...
Sorry, what was the paragraph again?
39.2.
Thank you.
39 subparagraph 2. And then, so far as deportation bail was concerned, this is going on to page 222 in Schedule 3. It's subparagraph 4, capital A. And you see that the technique that was used was to apply Schedule 2, paragraph 22, to a deportation case.
But still a person detained.
That's right, yes.
Not liable to be detained.
Not liable to be detained.
Right.
So the liable to be detained language was not present for deportation bail either. And you'll see from footnote 11 that that was introduced from 10th of February 2003, before which there had been no bail power in deportation cases, or no statutory bail power. And there was no bail power in deportation cases, therefore, at the time of Hardiel Singh, 20 years earlier. So, having drawn attention to the language, the next logical step is the Kadir litigation explaining what that language meant. But it's probably a useful point at which to introduce the factual situation that was relevant to the Kadir situation. The first place to go to, if I may, is this court's decision in Gardi, which is tab 29. Starting at page 556. I should say by way of introduction that we are not citing this for the law, because the law has moved on since then, but it's for the factual description of what was happening, which you will find at paragraphs 8 and 9. This is page 560. You'll see at 8 that it has been submitted on behalf of the applicant that those directions, that's to say directions for return to Iraq, would nonetheless put him at risk of persecution because there was no method of direct travel to the Kurdish area, the applicant's home area. The only scheduled flights to Iraq were to Baghdad, which was of course controlled by the Iraqi authorities. Adjudicator had before her a report approved by the then minister, which reads, and there's a quotation, halfway through the quotation, you'll see that UNHCR was not objecting to the return to northern Iraq of asylum seekers from that area who've been found not to be in need of protection. To that end, the government is in the process of exploring the options for returning Iraqi citizens of Kurdish origin to the northern part of Iraq, and these arrangements will be used to return such Iraqi nationals who do not qualify for leave to enter or remain. And then in paragraph 9, there's a quotation of what the adjudicator found. It's the second half of the paragraph. She says that it is possible that return to Kurdistan may be safe for persons such as the applicant in the future, but at present I find there's a real risk of significant harm if you returned via Baghdad. So the prospect of removal to northern Iraq was not a very immediate one on that description. This court's decision there was given on 24th of May 2002. A couple of months later, sorry, this is going on to tab 31, the end of July 2002, Mr. Justice Crane gave his decision in what we now know as Kadir. It was then called Huezen Kadir, page 582 of the bundle. And you will see, I'm not going to read all of this out, but you can see from paragraphs 2 to 4, and also at 7, reference to the same factual situation. And then at 584, there's a quotation of a letter from the Home Office saying it remains our intention, subject to the outcome of his appeal, to remove him to northern Iraq. As you are aware, we have been exploring a number of options for returning Iraqi Kurds through various neighbouring countries. Whilst it is the case that matters are taking longer to conclude than we would ideally like, progress is being made and our work continues. However, these negotiations are sensitive, and to reveal more of their details would risk jeopardising their outcome. And then this was picked up again by the Court of Appeal in Kadir. You have that at tab 33, page 663, paragraph 11. There's a quotation of the same letter, and then there's another letter quoted from the 3rd of May 2002. Secretary of State is currently investigating a safe route for Iraqi Kurds to return to northern Iraq. In those circumstances, granting exceptional leave is not appropriate. The point of showing you this factual background is this was approved by the House of Lords as some prospect of return, sufficient to regard the individual as liable to be detained, i.e. that the detention power continue to exist, even though obviously it would not have been lawful to actually exercise it at the time. Now, the decision in Huezen Kadir, as I've shown you, 29th of July 2002, because of the interpretation that had been given to the words liable to detention, Parliament intervened and legislated to provide Section 67 of the 2002 Act. You have that at tab 14 in the same bundle, and the provision is actually at page 236. can I draw attention to this because this section does remain in force, and we say that as a fallback to all of our other arguments, this is clearly applicable to the interpretation of Schedule 10. The section applies to the construction of a provision which does not confer the power to detain, but refers in any terms to a person who is liable to detention. And then it brings in a number of different categories of people, including, importantly, people who cannot presently be removed from the UK because of a legal impediment connected with the UK's obligations under an international agreement, which of course includes foremost those who can't be removed because they've made asylum or human rights claims. And if that's the reason why they can't be detained, because there's a barrier to their removal, then Section 67 puts them fairly and squarely within this provision. And then you see subsection 3, the retrospectivity provision. And clearly, this applies to the construction of the 2016 Act just as much as it applied to the 1971 Act. I don't need to ask you to turn it up, but the result of this was that in the Court of Appeal, this court in Kaitey, decided the case in the Secretary of State's favour on the basis of Section 67.
Yes.
And then the case then went to the House of Lords. What I think I should ask you to do is to have a quick look at what their lordships said, and Lord Brown in particular, about this. It's tab 5, starting at page 54, but the first paragraph to look at is paragraph 4, please, on page 58, where Lady Hale summarised the decision very pithily in the second sentence of paragraph 4. Person is liable to be detained where there is power to detain him, even if it would not be a proper exercise of that power actually to do so. And then going on to paragraph 66, sorry, page 66, paragraph 31. Lord Brown sets this out more fully. Lord Justice Mans was right to recognise the distinction between the circumstance in which a person is potentially liable to detention and can properly be temporarily admitted, and the circumstances in which the power to detain can in any particular case properly be exercised. And then at 32, the true position is this: pending means no more than until, words being used as a preposition, not as an adjective. And then skipping sentence, so long as the Secretary of State remains intent on removing the person and there is some prospect of achieving this. Paragraph 16 authorises detention meanwhile. Plainly, it may become unreasonable actually to detain the person, pending a long delayed removal, but that does not mean that the power has lapsed. He remains liable to detention, and the ameliorating possibility of his temporary admission arises under paragraph 21.
Why does there even have to be some prospect? If pending simply means until, why can't it be?
Well, that's a good question. I'm not sure that I would have a complete answer to that, but just thinking about the possible arguments against me, yes, if I were to try to advance that, I think the first thing which would probably be said is that there's a Padfield problem. If
yes,
there's no prospect whatsoever of removing somebody, then powers that depend on, or powers that last until removal would face a Padfield type problem. And that's, I think, the first thought that comes into my mind as a reason. Certainly, we don't dissent from this.
No, I know, but is this part of the ratio? Is this formulation of some prospect binding on this court? It may be. That's a genuine question.
Yes.
It says something about it in 33. Once that prospect had gone, this is in Tanti Land, detention could no longer be said to be pending removal.
Yes.
Yeah.
And even if it's not ratio, it's a fairly strong, clear statement.
Yes, yes, certainly. It is absolutely clear what their lordships were saying in this decision. But I'm struggling slightly with whether it was technically part
All
of
right,
the regulations.
well, don't worry. Anyway, for present purposes, you accept that if there is no prospect, then the power doesn't exist.
That's right. So I'm not going to resolve on that. We make two observations, therefore, about this. First of all, the decision is wider than Section 67, which confines it to a narrow trio of circumstances. And that, of course, is why Lord Brown then says Section 67 was unnecessary. But the second is that this is a decision of the highest authority on the meaning of the phrase liable to detention and its direct synonym, liable to be detained. They mean the same thing. In the context of a detention power, which is a pending power, i.e. pending a particular event. So even on the narrowest view of interpretation, that is what this decision relates to. And that is why we say that it is of the highest importance when one looks at the phrase where it appears in the current bail power. The next step, logically and chronologically, is to identify the relevant statutory construction principles. We've got quite a chunk of Bennion in. And rather than turn them up...
Sorry, just before you move on to that, can I just, at the risk of stating the obvious, or asking the obvious, can I just be clear what your submission is, why Section 67 of the 2002 Act was not a complete answer in B. Algeria? And the answer is because that's about a phrase liable to be detained, which was not the phrase being construed in B. Algeria. Is that right?
That's right. That's certainly a complete answer to why Section 67 was not relevant in B. Algeria.
Does Section 67 apply to everybody who is liable to detention within the meaning of Kadir, but can't in practice be detained because of the Hardiel Singh principle?
Section 67 applies to people who cannot be detained because of one of the three reasons specified in subsection 2.
Well, the second one of those, little 2b, is that there are practical difficulties.
Yes.
Is that addressing the Hardiel Singh problem, or is it addressing something else?
They're all potentially Hardiel Singh problems. Shorn of statutory language, can I just explain the broad areas they cover? I mean, first of all, there are the people who are making asylum claims that are going to take a long time to resolve, asylum human rights claims, take a long time to resolve. And so you can't detain them for years while that's being done. So that's category A. Category B are the Kadir type people, where they've got no asylum claim, that's been decided against them, but there's simply no route to get them home, so that's the practical impediment type of case. And the third type of case is, as actually at the time of Kadir and the 2002 Act, the Home Office was swamped, and that was a very bad time for decision making, as we I think all remember. And so just the administrative difficulties were delaying decision making, and the delays in decision making themselves would make it, or might make it, unlawful to actually detain somebody. So these are all Hardiel Singh type problems, but they were identified in the ways that they were. And that's why I say when you look at the decision in Kadir, of the House of Lords in Kadir, it was on a wider basis than Section 67.
Do you say that Mr. Kaitey falls in any of the categories A, B or C?
He certainly falls within A, because the problem there is that he's got this asylum claim which is taking a long time, too long, we accept, to resolve. One of the issues being his nationality.
Right. So I think you were taking us to
to
Benyon.
Benyon.
Yeah.
We've got a large chunk of Benyon copied. I don't think it's going to help if I just actually show you. May I cut this short by just giving you the references? We particularly draw attention to Principle 8.8. The page number is 2075. It's all under tab 80. So 8.8 at 2075, 10.1 at 2086, 10.2, 2089. I might just say a word about that. This is the principle. You'll see that Parliament doesn't act without a reason. It is almost always to make some change in the law. I seem to recall a rather picturesque expression: Parliament does not beat the air. I couldn't trace who'd said that, but that is the principle there. 10.4 at 2094, you need to find the mischief, and 10.5 at 2097, Parliament intends to remedy the mischief. And then 24.5, which you'll find at 2122, you construe legislation taking account.
Sorry, which paragraph?
24.5.
Thank you very
Principle
much.
24.5.
Yeah.
You take account of the previous law and its evolution. And 24.6 at 2126 is the Barras principle about the previous judicial interpretation of words and phrases that have already been used. And we say, of course, that applies in spades where it's not just actually liable to detention in the context of immigration legislation, but it's liable to detention when it's referring to a detention power couched in pending terms. So it's very, very specific what Kaitey is doing.
But what's said against you, I think, or at least one of the things, is that was to do with temporary admission.
We respectfully disagree with that. The decision in Kadir, although it was looking at a provision that was directly concerned with temporary admission, what it was looking at was the scope of the detention authority and whether or not the detention power continued to exist such that the person was liable to be detained. So it's wider than just temporary admission. It refers back into the detention power itself. And the detention power, in fact, there's the same detention powers now, pending removal, pending deportation, and so on.
Yes, in Baroness Hale's speech, she in fact drew an analogy with the mental health legislation, where she found some assistance, that there was a similar phrase, liable to be detained. If that's the right approach, that tends to suggest that this reasoning is not necessarily confined even to immigration.
No, it's not my submission that it's confined in that way, but it is.
No, that's right. That was a point in your favour, Mr.
Yes. And if necessary, I would gratefully adopt that. But I hope I've put my submission the right way around, which is that because we are looking at a context which is actually, I would say identical, because we are looking at liable to be detained under the exact same detention powers as were under consideration in Kadir. The previous judicial interpretation is something which applies to the phrase appearing in a new statute. Yes. So I can make that very direct submission, whilst at the same time accepting that, of course, Kadir might be capable of being applied more widely.
Right.
24.7.
Sorry, before you go on, you may be about to come on to this, but yesterday there was quite a lot of submission about the intention of Parliament not being subjective.
Yes.
But I mean, you accept that, I imagine.
Yes, I'm not dissenting from the way that it's put in the authority that is cited in Benyon.
So when one talks about a purposive approach, which as far as I'm concerned is the modern approach to statutory interpretation, if we need authority for that, the Supreme Court has told us that many times I think there's a recent case this year, Uber, an employment law case about Uber drivers, where Lord Leggatt said that the modern approach to statutory interpretation is that we seek what the purpose of the legislation is. We no longer ask, as a matter of dictionary definitions, what legislation means, because it's always intended to achieve something. That's not, you say, that's nothing to do with subjective intention of Parliament. It's an objective concept, but it's a purposive construction. Is that right?
Yes. I don't think I can disagree with any of that. That is the modern approach, and we say that when you apply that approach to this statute, that approach is entirely consistent with all of these principles of construction that have also come down to us through the ages and distilled by Bennion into these principles.
Well, where it may come into conflict, however, with another fundamental principle is what's called the principle of legality. Speaking for myself, I've never been quite sure that's an apt phrase, but it's the phrase we have. You know what I mean about that? The Sims principle.
Yes, yes.
We were shown yesterday Privacy International, which is about ouster clauses. BLGRE itself refers to the need for the clearest possible language. And the fundamental point that's made against you, Mr. Tam, is that here, whatever Parliament may have been trying to achieve, it didn't succeed because it didn't use the clearest possible language, and it should have said something like, even if cannot lawfully be detained.
And that is the reason for citing these other principles of statutory construction, because the context, the previous previous statutory language, previous judicial decisions interpreting that statutory language, the adoption and repetition of the same statutory language in exactly the same context. These are all things which point to what the words mean. I've accepted that if you ignore all of the history and you just look at the words of paragraphs 1.1 and 1.2, there might be some force in the appellant's submissions. But it's when you add in all of these other things, which are certainly not prohibited by the purpose of construction approach or by the principle of legality or anything, add in all of these things, it is absolutely crystal clear what these words mean, given how they're used by Parliament in the statute. You don't need to go into subjective territory to do that. It is the reuse and the repetition of the same words with the established meanings that they have.
So the history can inform the answer to the question, have the clearest possible words been used? It's not just a textual question.
Exactly.
But is the language? I don't know. You may be about to come back to this. Forgive me. But do we need to look at the language? And the provisions that you say just don't make any sense. Particularly, I think it was subparagraph 5 you told us doesn't make any sense. Do we need to look at that again?
We do, and I'm going to come on to this in the chronological steps. Because of course I accept we need to look at that, and there are some specific points that I need to address. But so far as an overarching submission is concerned about whether the words have a clear meaning, they do, given the background, context, and the way that this legislation has evolved.
Yeah. Forgive me for prolonging the discussion, but this is important, Mr. Tam. What may lie at the heart of this appeal is the potential conflict between the principle of legality and these other presumptions or principles of construction. But I would like your submissions at some point to help us on what exactly the principle of legality entails, because we've had it cited to us quite a bit yesterday, but as I understand it, and I may be wrong, what that's about, and Privacy International is not quite the same, but let's take that by way of example, because that's about ouster clauses. What's being said, I think, in those cases is that if Parliament wishes to violate fundamental rights or wishes to prevent judicial review completely, it must say so in the clearest possible language. But are we in that territory here? First of all, we're not in Ouster Clause territory. But secondly, this is really my question to you. Are we in the territory of Parliament wishing to violate fundamental rights?
No, we say we are not. We accept that the powers that have been conferred by Schedule 10 are capable of affecting fundamental rights. So I want to make clear I'm not shying away from that.
Yes.
But we are not in the territory of the legislation violating fundamental rights. And the reason is this. The powers can be exercised, but there is an infinite spectrum of conditions, or near infinite spectrum of conditions, that can be imposed on immigration bail in the new system. They can, learned friends have concentrated on the particularly intrusive ones that could be imposed, but at the other end of the scale, about which you've heard nothing, the requirement of the statute is for only one condition, and it may be a condition simply of reporting to the Secretary of State on one occasion. That is as close to unconditional bail as you can possibly get. And so while the statutory powers are capable of being exercised in a way which would affect fundamental rights and would then have to be justified, it doesn't mean that the legislation is legislation falling into the category of undermining fundamental rights, such as taking away an entire route of judicial approach.
Yeah.
So we say we're not in that territory at all.
So forgive me, would you accept, following on from that, then, that all of this regime is still subject to the Human Rights Act?
Oh, yes.
So if, for example, on the concrete facts of a particular case, the conditions which somebody was subject to amounted, say, to imprisonment, such an extensive curfew that it amounts to imprisonment, that would either be unlawful under the Human Rights Act, or it would be justified, but it would have to be justified under the Human Rights Act. Is that right?
Yes, yes.
But you say that doesn't touch on what interpretation one should give to the phrase liable to be detained. Is that right?
Exactly. Or it doesn't mean that you have to resort to principle of legality
or Section 3.
Or Section 3 to change the meaning of the statute. The statute itself is perfectly fine interpreted on what one might say ordinary canons of construction. It's the exercise which may have to be looked at in human rights terms.
Right, thank you.
Yes. Just the last 2 points from Bennion, 24.7 at 2132, explanatory notes can be used as an aid, and 2420, which is at 2137, that the courts themselves, when interpreting a statute, will use previous judicial decisions and settled practice. Sometimes those previous decisions may, of course, be binding.
Well, it can't be binding on what a new piece of legislation means. Because the question is what a new piece of legislation means.
Yes. In the abstract, sometimes those decisions can be binding. Not here, because, as my lord says, it's a new piece of legislation.
Right.
So we say this is all strong background for looking at whether there's a clear meaning of the words used in Schedule 10, given all the similarities to the previous legislation. I'm not going to repeat those observations. The next step, and again looking at this chronologically, is the B Algeria litigation about bail. Can I at this point turn up this court's decision in that litigation? This is tab 48. You'll notice from the title that there were actually two appeals to this court. Mr. Vaughan, who unfortunately isn't here today, and I actually managed to make sure that the case could come efficiently before this court, and why the two appeals got here at the same time. The bail appeal was of course the one that we are concerned with here. I said that I would show you paragraph 33, where Lord Dyson referred to Mitchell and Mitchenham. This is on page 1230. He said the power to grant bail presupposes the existence of and the ability to exercise the power to detain lawfully. For this reason, the writ of habeas corpus can still issue where a person is on bail, and there he cites Mitchell and Mitchenham. And then he also cites in re Armand about the habeas corpus, and I've already shown the court the reasons why we respectfully say that both of those cases were misunderstood. And then at 34, he sets out his conclusion. He said, third line, I do not believe it can have intended to authorise a grant of bail where the power to detain cannot be exercised, even if the power can be said to exist. And then he distinguishes Kadir. And then, for present purposes, I should then go next to section 61 of the Act. I should have told you that that decision was 6th of May 2015. And then the 2016 Act was passed on the 12th of May 2016. You'll see this at Authorities tab 1, page 6. And then the original form of section 61 is on page 7.
Yes, thank you.
So, section 61.3, which was the provision that came into immediate force on the 12th of May 2016 and with retrospective effect, as you can see from subsection 5, is a key part of understanding what Parliament was doing here. It was directly addressing paragraph 22 bail. It imported the phrase liable to detention as part of the definition of the people to whom it applied, which we say, for reasons which were explained, must have been an importation of that phrase with its Kadir meaning, given that it's referring to exactly the same detention powers. And then it had the phrase, even if the person can no longer be detained. So applying all of those, all of the principles of interpretation that I've already addressed, I pose a rhetorical question, well, what was section 61.3 there to do? The one thing it cannot have been there to do was to make provision only for cases in which the person was liable to lawful detention, which is the way in which learned friends would ask the court to interpret the current statute. If that had been the limitation of the ambit of 61.3, 61.3 would have achieved absolutely nothing. Even under B. Algeria, anyone who could be lawfully detained could be bailed. And the words, even if the person can no longer be detained, would have added absolutely nothing to the position under B. Algeria. Learned Friend's interpretation as applied to 61.3 would not only transgress the principle that Parliament must be taken to be doing something. Parliament was not just doing something here, it was doing something with immediate and retrospective effect. An echo, really, of what had happened with Section 67. And so we respectfully say that this can only be read as meaning that the person can no longer be detained because that would be, say, beyond Hardiel Singh limits and unlawful. The whole history of what had happened up to then points to that.
Forgive me, Mr. Tam, on your submission, was this enacted to reverse the effect of the Algeria in the Court of Appeal?
Yes, absolutely.
Why wasn't that then a complete answer in the Supreme Court? Because this has retrospective effect.
Because the Supreme Court asked, and the Secretary of State. Sorry, let me start that again. The Supreme Court asked the question whether Section 61 was to be relied on, and the Secretary of State declined to do so on the basis that the underlying question about statutory interpretation required resolving. So in a sense, it was deliberately, the point was deliberately not taken before the Supreme Court. I should say, caution that I'm saying that from memory,
yes.
but I'm pretty sure that's what happened.
In paragraph 23 of the Supreme Court judgment said in terms that the Secretary of State indicated she did not propose to rely on Section 61.
Well, I'm grateful.
Yes, I've noted that, but it might be thought that the court should apply the law of the land if it has retrospective effect. That's the effect. But you've explained that you wanted a resolution of the argument.
Yes, and as I recall, that was the rationale. It wasn't the approach taken by this court in Kadir, because you will see from the judgment, if you look at it, that was raised by the court, and then that's how Section 67 became the decisive part at this level. But yes, Section 67 was deliberately not taken before. Sorry, Section 61 was deliberately not taken before the Supreme Court.
Yeah. Right.
And linguistically, we draw attention to the fact that the sense of the phrase "can no longer be detained" is a reference to "cannot be detained," even though it then also inserts the time point there. It is not and cannot be read in the sense of the person should not be detained any longer, or it would not be a good idea to detain the person any longer. The word "can no longer be detained" imports the sense "cannot." And we say that between this and all the other conventional statutory construction points we've made, the policy here behind Section 61.3 was clearly to widen the ambit of the bail power to everyone who would fall within the Kadir principle. That it's the only sensible reading of this particular provision. And we respectfully say that is also, for what it's worth, supported by the explanatory notes about this. You have those at tab 81. And if I can ask to go straight to page 2195.
I'm sorry, which tab is it?
It's tab 81. And at the bottom there's the note about Section 61 itself, paragraph 286, subsections 3 and 4 make clear that a person may be released and remain on bail where they are liable to detention.
I'm sorry, which page are we on?
Oh, so 2195,
Thank you.
paragraph 286.
Yes, thank you very much.
Where they're liable to detention, even if they can no longer be detained. This section returns the law to its previously settled position before the Court of Appeal's judgment in B. Now, I know that explanatory notes wouldn't be a strong pointer if everything else pointed the other way, but that word returns is a clear, or is clearly consistent with everything that you get from the language of the section itself, which is that it is turning the clock back to a position before the this court's decision in B.
Do you have any submission as to what the reference to the previously settled position was?
Well, the problem with that is that if I try and make submissions about how the law was generally understood at the time, there'll be all sorts of things said against me. So I'm
controversial.
Not, yes, it would be controversial. It's controversial every time I try and raise that, either in the context of this or the Kadir litigation. So I'm
it was rejected by the Supreme Court. Your submissions on what was the settled law. Yes, I think that your Lordship may have heard that sotto voce. It would be controversial if I did that. But it is the word returns that suggests that there was an element of reversing what the
what the Home Office thought the law.
What the Home Office thought, yes. And for what it's worth, explanatory notes are there. But the point is, it is actually consistent with everything else that you get from the language itself, which is why I started with.
Do we need any more? Forgive me, Mr. Sam. Do we need any more from this than that the intention of this enactment was to reverse the effect of the Court of Appeal decision?
No, I don't think I need to ask you to do any more. It is precisely that point. It was to reverse B. Algeria. And then linguistically, and where the link is the linguistic link. Because in order to do that, and in order to make section 61.3 do something, the phrase liable to be detained, or liable to detention, must have had the same meaning as in Kadir. And where there's a reference to even if a person can no longer be detained, it must be referring to people who cannot be detained because it is now unlawful to do so. And those are the two key points. Otherwise, section 61.3 doesn't work and doesn't do what the explanatory note says it set out to do.
When section 61.3 came into force, do you accept, as was submitted by Ms. Harrison, I think, that it only applied to people who were in custody, were being detained, not to people who were already at large? I think she relied on the words may be released and remain, which suggests that it's somebody who's currently detained but may be released once you get. If you know that someone you're detaining has got to the end of their Hardiel Singh period, you may release them.
Yes. On that point, I do agree with that, because this this section, or this subsection itself, refers only to the paragraph 22 bail power, which could only apply to people who had been detained at some stage and were then released. Yes.
There was then no power until Schedule 10 comes in. When you say it changed, there was then no power to put someone on bail conditions unless they were in custody and you were releasing them.
That's right. Yes. But the bridge here is those that the meaning of those phrases in 61.3, which had to have those meanings for 61.3 to work. And thus finally we get to Schedule 10 itself, which 18 months or so later comes into force and replaces the previous structure. Can I please make a number of general points about this, which I think are evident from the many times that we've looked at this already. On any view, it was a radical reworking of the previous mechanisms for the control of individuals who are subject to immigration action. It abolished temporary admission and what I've been calling temporary release, the Schedule 3 powers to put people on restrictions. Those two mechanisms had been in the 1971 Act from the very beginning. And what Parliament did in Schedule 10 was to create one single category of immigration bail. The transitional provisions show, reinforce, that all pre-existing TA, temporary admission, temporary release cases were to be folded into this new system of immigration bail, alongside those who had previously fallen under bail powers.
Can we use a statutory instrument which was passed at the end of 2017 to construe an act that was passed in 2016?
With respect, I'm not doing that because that transitional provision is actually in the Act itself. Can I ask you to turn up paragraph 13?
Well, 13 is the regulation making power.
It is, but it sets out clearly what Parliament intended the regulation to deal with, and that is that the regulation should bring in the temporary admission, temporary release people into the new system of immigration. So it is actually in the Act.
So you derived that proposition from paragraph 13 of Schedule 10?
Yes.
Right.
Yes. And then the regulation simply put that into effect.
Can we just have a quick look at that? Where is paragraph 13?
It's page 20 under tab 3.
Thank you very much. Yes. Yes, I just wanted to be clear that subparagraph 1 applies to the categories set out in subparagraph 2. And are you able to help us with which of those this appellant fell into?
He would have been 13(2)(d).
All right.
Liable to be detained but was not so detained.
Exactly.
And that is true, however it came to be that he wasn't detained. Is that right?
Exactly that. Exactly so, yes.
All right. Thank you.
And your submission is, even though this is only a regulation making power, it by itself, without looking at the regulations themselves, shows that Parliament intended all these categories to be folded into the new category of people granted immigration bail. And indeed, subparagraph 4 refers to people treated as having been granted immigration bail as a result of falling within particular categories.
Yes, exactly.
Yeah.
So it's fairly clear what the regulations were envisaged
Yes.
that they would say, and in due course did say.
Yes, but also it's an indication of what Parliament itself thought this new system was going to cover. Yes. And so the judge, we respectfully say, was entirely correct to describe the new system in the way that she did. I'll just give you the paragraph numbers, paragraph 75 and 80 to 81. We say that this shows why the ancient law about bail, in its various meanings, has even less relevance to Schedule 10 than it had to paragraph 22 bail. There had been statutory intervention, and this is a radically reworked system. And what Parliament has done, clearly, is to create a new system called immigration bail that embraced situations that formerly were not considered to be bail in the old language. And so the interpretative approach to Schedule 10 must approach the schedule as a whole. Certainly, we respectfully say it cannot depend simply on the fact that Parliament chose to call it immigration bail rather than, for example, immigration restrictions, which it could perfectly well have done. The precise choice of word there is much less important than what the section actually does, and the situations which Parliament clearly intended the schedule to cover.
But I think what's said, or one of the points made against you, is that now the conditions that could be attached could be much more restrictive than the ones we saw earlier, which were about things like occupation, reporting to the police only. But for example, an electronic tag could not be imposed under the old legislation. And I think what it said is that once you get into that territory, a much more strict interpretation should be given.
Well, with respect, we say that that's not correct, because since February 2003, in deportation cases, true it is that that one route would have been restrictions under paragraph 2.5 of Schedule 3, which has only the limited selection of restrictions. There was also the bail power imported from Schedule 2, and that's paragraph 2, 4 capital A.
Yes.
And so it is not right, we respectfully say, not right to say, or not right to assert, that all of a sudden deportation cases could be subject to much more stringent restrictions than they ever could under Schedule 3. That's simply not the case. Learner Friend has in fact referred to some of the I think SIAC cases where there were very stringent restrictions. There was one person who was actually literally on 24-hour house arrest for a period. They were deportation cases, and that was by importation of the Schedule 3 powers. For serious cases, this has affected no change. The restrictions could have been equally onerous then as they are now. So I've already identified that the two central questions really are: what does paragraph 1.2 mean, and what does paragraph 1.5 do? I think the most efficient thing is probably if I just go through these subparagraphs in turn to make my submissions, and these will answer some of the points made against me. First of all, paragraph 1.1, we accept it broadly reproduces the scope of the old paragraph 22 bail power, because on its face it applies to people who are actually detained. The phrase "is being detained" is a state of fact. We accept that if you look at paragraph 1.1 in isolation, if there had been no other legislative intervention, then BL Algeria might well apply to its interpretation. But what we do say is that paragraph 1.5 widens this, and I'll come to that when I get there. But the effect of 1.5 is to disapply the BL Algeria limitation. And then the next question then is, what does paragraph 1.2 do? We say that on any view, it is clearly intended to add to the ambit of those who may be granted immigration bail, because it widens that scope beyond people who are being detained. On its face, there is no requirement for the person to have been detained at any previous time. It simply uses the phrase, "the person is liable to detention." Given that Schedule 10 appears in the same statute as 61.3, about which I've already made submissions, and that Schedule 10 was intended to replace 61.3, which was to be repealed immediately if Schedule 10 came into force, it must have been, Parliament must have been using the phrase here in exactly the same meaning as it had used it in 61.3. That's also consistent with a purposive approach, which is to, or which looks at the fact that Schedule 10 was taking over from all of the previous temporary admission, temporary release, and bail powers. The old bail powers limited to people who had been detained, but TA and TR were not so limited, and paragraph 1.2 is entirely consistent with that purpose. We have the fallback position about section 67 in any event. I don't need to repeat that submission, nor do I need to repeat the submission that the provisions or the detention powers referred to were exactly the same detention powers as were in Kadir. So we respectfully say that the Kadir meaning must be the meaning that Parliament was using in paragraph 1.2. BID did have a submission that this reading of paragraph 1.2 makes paragraph 1.1 OTOs, but I've already drawn attention to the fact that that was always in paragraph 21 as it was, so there is nothing to the point there. Can I then turn to a point made against me about paragraph 1.3, which is that the FTT appears to have power only in relation to people who are actually detained, i.e. it's not widened in the way that paragraph 1.2 is. Well, we say there's nothing odd about that because it's contemplating bail applications by people who are detained and who have not been able to persuade the Secretary of State to release them. So there is really nothing odd about that at all.
So you accept the FTT is not given express power to release on bail someone who's not in detention?
Exactly. There is a point from 1.5 that I'm going to make, because one of the things that was then said was that if you look at 1.5, it appears to be a provision that might confer jurisdiction on the FTT to do exactly that. But when you ask and answer the question, what does paragraph 1.5 do, you'll see that there is not actually such a problem. But textually, can I just ask you to look at 1.5? Not only is there the phrase liable to detention in 1.5a, but also in the main body, there is the repeat of the phrase, even if the person can no longer be detained, for the same reasons we say that's got to mean the same as was in section 61.3.
Robin, our submission of 1.3 was can no longer lawfully be detained, so that the FTT's jurisdiction is limited to those who are lawfully in detention.
Yes, I understand that. The phrases in 1.5a must have the same meaning as in section 61.3. And what paragraph 1.5 therefore does is it disapplies, and because we know 61.3 was there to reverse B. Algeria, 1.5 disapplies the lawfully detained limitation that would otherwise be capable of being read into paragraphs 1.1, 1.2 and 1.3. Inexorably, that is where you get to by applying the canons of construction and looking at the history, because we say section 61.3 reversing B. Algeria, 1.5 adopting the same phrases and must be adopting the same meanings, and therefore the only thing it can be doing is to disapply the lawfully detained limitation that was the decision in B. Algeria.
And that applies to the FTT under 1.3 just as much as the Secretary of State under 1.1.
Yes.
So a distinction between 1.1 and 1.3 on the one hand and 1.2 on the other is that 1.1 and 1.3 are people who are in custody on your submission, whether lawfully or not, whereas 1.2 then deals with people who aren't currently detained.
Exactly. But in all those categories, the lawfully limitation has been disapplied. That's the purpose of 1.5. That's what it's there to do. Otherwise, 1.5 doesn't do anything. And that would contravene one of the principles of interpretation.
This is really just going back to what you said was happening with section 61.3.
It is, but I'm emphasising this because it is an adoption of the same language. That's why this has got to be what it means.
And there is a distinction in wording between 61.3 and 15A, which is that 61.3 referred to a person being released, whereas this refers to a person being granted.
Yes.
Is that because 61.3 was confined to people who were detained, but 15A extends to people who are not actually in detention? They can still be granted bail.
Exactly. That's right. Because Schedule 10 covers the wider scope, and so released in 61.3 makes sense in the more limited context that it's applied to. But the key phrases are the same. And that, finally, and it's taken a long time to get through the history, that finally is the nub of what we say this means. The section or the schedule works when it's read like that. It would be, reading it in any other way would be to ignore everything that's gone before in the history leading up to Schedule 10. And it would leave bits of Schedule 10, especially paragraph 1.5, doing absolutely nothing. Parliament beating the air.
Right.
We would also raise this one final point about 1.5, which is that we've all focused on 1.5a because it has the phrase liable to detention. But of course there is 1.5b as an alternative, which could apply to people who are not even within a detention power at the time. If learned friends were right about the meaning of the phrase even if the person can no longer be detained, 1.5b simply would have no scope for operation at all. That can't be right. Can I deal next with paragraph 10 and the consequences of breach? Because that is something that learned friend Ms. Harrison made much of. This is at page 17. Paragraph 10.1, we say is clear authority for, well, it's an arrest, it's a power of arrest, so there's a separate power to take away somebody's liberty, which has particular conditions, quite familiar wording. And then once the person has been arrested, there is then the provision at 10.9, which obliges the person to be brought before the authority, and then it says may be detained under the authority of the Secretary of State in the meantime. And so we say by comparison with the detention powers that I've showed you at the beginning, clearly this is a new detention power that is exercisable, but in these specific conditions. These are both, that's 10.1 and 10.9, are both short-term detention in the event of breach or apprehended breach. And even if a person is to be regarded in general as beyond the Hardiel-Singh limit, if there is something that changes the position, of course there is no Hardiel-Singh problem with a period of short-term detention. Just as in another context, there's no problem with a short period of detention for immediate removal, even in cases where people couldn't be detained otherwise. So there's no problem with those particular provisions, even if my construction of paragraph 1 is correct. We also say it's not right to say that the detention authority under 10.9 is unlimited in time, the requirement is that the person has to be brought before an authority as soon as practicable, and the 10-9 short-term authority can only last for that length of time. True it is, it doesn't say 24 hours anymore, but it's got to be quick. And so that is not a proper objection to this reading of Schedule 10. The bigger question is what happens if, on substantive consideration of what is to be done, the person is in a position where it would not be lawful to re-detain him before Hardiel Singh reasons. And this is the problem that my learned friend poses over and over again. We make these observations. 1012A, which sets out the two options, does not make it mandatory to re-detain the person. If it is at that time not lawful for Hardiel Singh reasons to re-detain him, well, the breach will just have to be dealt with under 12.1b. 1012b. There might have to be different bail conditions, maybe more stringent bail conditions or whatever. The person doesn't have to be re-detained. So there's no Hardiel Singh problem with this. And of course, there are other consequences that are still available, perhaps prosecution or whatever. And so there is no difficulty there. And there's also no revolving door difficulty because, of course, the whole trigger for paragraph 10 is that something must happen to justify an arrest. And you couldn't have a situation where somebody's simply in and out all the time. That wouldn't be lawful.
What about Article 5.1f?
Oh, yeah, just there's the next topic, if I may. Are there any ECHR problems? As a matter of principle, there can only be any potential Article 5 problem at all if bail is on conditions that are so onerous that they deprive the individual of liberty. You can't just say in the abstract it is theoretically possible that somebody might have conditions that do that.
Forgive me, I was referring to the possibility of detention under the authority of the Secretary of State in the meantime.
And the same applies to
Right,
arrest.
yes, sorry, yes. I jumped into the more general submission. On that specific problem, there's no Article 5.1f problem. The whole purpose of immigration detention is to make sure, is to make sure the border control is effective. That's within 5.1f. If somebody is released on bail, but the bail conditions are to the same end, even though they don't engage 5.1f because there's no detention. If what you do is detain somebody, arrest or detain somebody in the short term because of a problem with immigration bail, that must be as much part of detention for enforcing the border control as substantive detention for somebody who can be lawfully detained. It's not somehow completely divorced from maintaining immigration control.
If you look at the text of Article 5.1f, it doesn't say for the purpose of maintaining border control.
No,
The view to deportation.
It says to prevent as effecting an unauthorised entry or with a view, against whom action is being taken with a view to deportation.
yes.
So which is it? In the case of someone like Mr. Kaitey, if he breaches his bail conditions and is first arrested and then detained temporarily in the meantime by the Secretary of State, how does that fit within Article 5.1f?
Well, it's going to be either or both at different times of the procedure.
Is it to prevent him effecting an unauthorised entry into the country?
Yes, because he may be at some stages. So probably impossible to do this without having the full chronology and looking at every single step along the way, because it's quite a complicated one. But there will have been some stages in the chronology where detention, if effected, would have been to prevent him unlawfully entering the country to maintain the border control at that point. That's typically used for people who say that they've arrived, they've got no obvious reason to be here, and they're detained. That would be the natural part of the article to refer to. There were times in this appellant's case where the Secretary of State was trying to deport him, and that's still the position now with an extant deportation order, and so you regard it as falling within the other part of the article. I don't think that there have been many cases that have turned on whether the individual was within one or other of the parts of the article where clearly one or other must have applied to him. In general, 5.1f is there to maintain the border control, either to stop people coming in or to make sure you can remove people who should not be here. The central point is that the short-term detention to enforce the bail control, where the bail control is there to maintain the border control, that short-term detention is also detention for the purposes of maintaining border control. So there's no 5.1f.
Yes. Speaking of myself, I may be wrong. I'm not sure we need to decide this in this case. There may come a case in the future where somebody is purportedly detained or arrested under these powers and wishes to argue that this is all a breach of my convention rights and it doesn't fall within Article 5.1f. But on your submission, does any of that bear on the issue interpretation which we do have to decide under ground one in this appeal?
We respectfully say that all the Article 5 arguments are immaterial to the outcome of this case, because Article 5 only arises in a case where somebody is complaining about their detention or about bail conditions which are so onerous that they say amount to a deprivation of liberty. They don't arise here, and in any event there will be case-specific remedies. Notably, please can I have my bail conditions relaxed to deal with those. It's not something which is going to affect the overall lawfulness or interpretation of Schedule 10.
It would be very different if the interpretation that you put forward necessarily led to Article 5 breaches.
Yes, exactly. But that is simply not the case here. Similarly, there's no Article 5.4 problem. Just headline that, because you can always apply for judicial review of your detention, or for that matter, make a bail application in an appropriate case. So we say the objections that are raised to our argument are sorry. The objections raised to our arguments are without weight and without merit, and we invite the court to reject them. It works in the way that we argued before the judge, and which the judge accepted. And on this main point, we invite the court to uphold the decision.
Yes. Mr. Tam, can I just ask you how you're doing according to the agreed timetable?
Yes, I had thought, and I don't think anybody's told me I'm wrong, but I had until 12:30 on the timetable.
Yes.
And I will be able to
Very
complete
good.
my submissions within that.
Thank you.
Can I then turn to ground 3?
Yes.
The suggestion is that there should be a Hardiel Singh type time limitation on the exercise of these immigration bail powers. I say time not in the sense of strict hours and minutes, but there comes a time when you can no longer do it. Of course, we accept there's a Padfield limitation. That's Hardiel Singh Principle 1. There's always going to be a Padfield limitation. There's no dispute there. But the time limitations that come into Hardiel Singh 2, 3 and 4 are not necessary for the proper functioning of Schedule 10. There were reasons why Hardiel Singh imposed the implied limits on the exercise of the detention power. First of all, detention is a binary thing. You are either detained or you are not. BID submits that actually Hardiel Singh is a multifactorial assessment. That's the assessment of whether or not your detention is lawful or not at any particular time. But the question of whether you are detained or not is actually a binary concept. The second point is that at the time that Hardiel Singh was decided, there was no bail power. There was only the power to release on relatively light restrictions. And clearly there would be a large category of cases, or larger category of cases, where the Secretary of State thought those restrictions would not be enough, and then the person would be detained, because that was the only other thing that could be done. And the third point was that there was no express limit on the exercise of the power to detain at that time, if the Secretary of State thought that temporary release restrictions would not adequately protect from the risks. And that is why back in 1983, I think Mr. Justice Wolfe set those implied limits on, as we now understand it, the exercise of the bail powers. That's a context in which they came in. But limits like that are simply not necessary where under Schedule 10, first of all, you're not detained, you're being granted immigration bail. That's the first thing. So following Yusuf ud-Din, prima facie, you're at liberty. The second point is that the conditions of your liberty or your non-detention can be set on a near infinite spectrum to reflect the circumstances of your case. Third, those conditions could be as light, as I said, as a single requirement to report once, so virtually unconditional, practically unconditional bail. And then fourth, and most importantly, there is always judicial control over the calibration of the conditions. If the FTT grants bail, it may keep the power to set and reset and modify conditions. If it's a Secretary of State who's deciding that, then there is always judicial review of the Secretary of State's decisions.
There's no express right of appeal against particular conditions.
No, that is not in the feature of Schedule 10.
You could get judicial review, presumably.
You get judicial review, yes. But because conditions of your immigration bail can be so infinitely variable and are subject to judicial control, there's just no need for the implied Hardiel Singh time limitation, which would, if Learned Friend was right, bring the entire immigration bail to a shuddering halt as soon as you hit the Hardiel Singh type limit. And there's really no need for that. So we invite the court to reject it on those for those reasons alone. But there is one further point, which is workability. Now, in B. Algeria, we did argue that implying Hardiel Singh limitations into a grant of bail would cause some conceptual problems if you're deciding whether or not it was still lawful to maintain somebody on bail and having been granted bail, by reference to the hypothetical question of if they were detained now, would that detention be lawful or unlawful? The Supreme Court rejected those arguments. I'm not going to go back over that. But the workability problem is actually magnified many times in the Schedule 10 context, because the question would be, the hypothetical question would be being asked in respect of people who had never been detained, whom the Secretary of State did not intend to detain now, because she wants to grant bail, and who might never be detained in the future, because they're simply not the sort of case where detention is even a realistic option. Bid's argument would mean that even in those cases, the Secretary of State or the Tribunal, when granting or considering the maintenance of bail, would have to ask, would it be lawful to detain this person now? It's a question which is so far removed from the circumstances of the case that we say that the submission should be rejected for that workability problem alone. The control is by controlling the conditions and making sure conditions are acceptable for the circumstances of the case.
We heard quite a lot of submissions yesterday from Mr. Vinsky, citing cases like Leach and Sims, effectively that there's an implied limitation on the discretionary power concerned, along the lines of that the condition must be reasonably necessary. Do you accept that, or do you not accept that?
Well, I would accept that any condition would have to have a justification. I don't think that I would accept the precise legal analysis that Bid puts on it, not least because cases like Leach and Sims were concerned with fundamental rights. And here, many people will be on conditions that really don't affect their fundamental rights. But clearly, the Secretary of State or the Tribunal should not be imposing conditions for which there is no reason, no justification, and so on. So it's a broad principle, of course, I accept.
So the usual controls of judicial review, which include Hadfield, irrationality, you accept that those would apply?
They must apply.
Yeah.
They must apply.
Possible arguments about proportionality.
Possible, yes, indeed. Don't want to wade
No,
into difficult territory now, but possibly. And of course, if there is a case where, say, Article 8 is genuinely engaged, then of course proportionality, ECHR proportionality through.
It's really the time, it's the temporal aspect of Hardiel Singh, which you have a fundamental difficulty with accepting, don't you? And you say that conceptually it makes no sense because it was developed in the very specific context of administrative detention. And of course, we all know the common law tends to view administrative detention, well, with great jealousy.
Yes. Exactly so. Exactly so. Just no reason to import it into this context.
Right.
Can I ask, Hadfield is the principle that powers have to be exercised for the purpose for which they were conferred. What do you say the purpose for which this power was conferred is?
It's to make sure that there is an element of control, so far as necessary, over people who are subject to immigration action. Stop them absconding, in some cases to stop them reoffending or being a risk to national security or whatever. That's the purpose, and that's well established. And so conditions would have to be directed towards that end.
But it could be that they shouldn't work, for example.
Yes,
or should not work in jobs where there are other people who are in the labour market and they deserve the first chance to apply.
Yes, I mean, all these things to protect the integrity of the immigration control.
Right.
So then can I move on to ground 4, which I can do very quickly?
Yes.
It's important to understand what is the extent of the dispute between the parties, because we accept, in broad terms, that if there's no prospect whatsoever of a person's removal, that there will come a time when the person will have to be granted some form of leave. Can I just give you the reference to Huez and Kadir in the High Court, Authority tab 31, page 584. You'll see a quotation from, I think, the Secretary of State's skeleton argument then. There are disputes as to exactly how it's formulated. I'm not...
Just trying to keep up with you. Where are you going next?
Kadir first instance.
Kadir first instance.
Right.
Authorities 31 at 584. I'm just going to give you the reference because you'll see that it's been accepted for decades that there must come a time when somebody has to be granted leave. The question is, when does that time come? That's controversial, and we don't need to...
Well, even somebody who's subject to a deportation order has to be given leave.
Well, if somebody is subject to a deportation order and a time comes when, for some reason, they have to be given leave, then the deportation order would have to be probably revoked.
Be revoked,
yes, because it would make no sense to have them the two side by side.
But you couldn't possibly have leave and be deported, be subject to a deportation order at the same time.
Exactly.
Yeah.
So the question really is when is that point? That is controversial, and I don't want to get into it too deeply. But the current route, as understood, is seen from RA Iraq and AM in the upper tribunal, which is that the time for granting leave comes when Article 8 ECHR requires leave to be granted. This is not the place to be arguing about that. What we do dispute is what is left in the appellant's argument, which is basically that the grant of leave must be exactly coterminous with the boundary of the Schedule 10 bail power, because what they're saying is as soon as you get to a point where you can't be granted bail on their argument, when you can no longer be lawfully be detained, you must then immediately be granted leave. And we say that is the thing that is not right.
Why is it not right?
Two reasons. The first is that falling out of the field of bail, wherever that comes, does not immediately and automatically constitute an Article 8 claim to leave. So that shorthand saying does not immediately mean that it would be an Article 8 breach not to grant you leave at that point. We say that if nowhere else, AM, which is Authorities 60, tab 60 at page 1574, you'll just see from the head note, the bar for Article 8 claims here is set high, and that refers back to RA Iraq. But the second thing, and this is the one thing I do want to show you, is that there is a statutory indication in Schedule 10 itself that these two concepts are not exactly coterminous. And this is, please, page 10, tab 3, page 10. It's paragraph 1.8.
Yep.
Bail ends in one of these cases. The first one is where subparagraph 5, that's the one we've been looking at centrally, can no longer be detained, applied to the person but no longer applies. So that they have been on bail because of 1.5 at some stage.
I'm sorry, which provision are you reading?
Yes, sorry, I'm looking at paragraph 1.8a, which is on page 10.
Oh, sorry. Yeah. Thank you.
So 1.8a is the case where the person was on bail because of 1.5, but bail comes to an end because the detention powers just doesn't exist anymore. So he's fallen out of bail even on a Kadir basis. But that's distinguished from 1.8b, which is where the person is granted leave to enter or remain in the UK. So the two separate categories there show that even Parliament was contemplating that there would be a situation where somebody would fall out of bail because they no longer satisfy even the Kadir requirement, but they are not immediately granted leave to enter or remain. And we say that's all of a piece with the high hurdle that there is set out in RA Iraq and AM for a grant of leave on this basis.
But what is the status in law of such a person? So they're not in detention because they can't be detained. So they're not on bail because they can't be bailed.
Yes.
But they don't have leave to remain either. So what's their legal status?
Well, they have no status. It's been described as limbo, but that's not a very apt description. They simply have no status, but they are equally subject to no bail control. So they can't have conditions imposed on them. I accept it's an unsatisfactory place for somebody to be in the long term, but that is why the Secretary of State has always accepted that if you're there comes a time when you will have to be granted leave of some kind. But the argument that I'm having to face is that the grant of leave is exactly coterminous. As soon as you fall out of bail, you must be granted leave, and we say that's not right. There are two other reasons. First of all, constitutionally, it's not right because it's for the Secretary of State to grant leave, and the appellant's argument would basically mean that the court looking at bail would also be deciding on a requirement to grant leave, and that, we say, is not right. If leave is required for Article 8 reasons, it should be applied for. If refused, there's an appeal to the tribunal, and so on and so forth. That's the proper route. To make these exactly coterminous would transgress the Secretary of State's function of deciding whether or not somebody has a legal right to
But if there was only one rational exercise of that power open to the Secretary of State, why could a court not make a declaration to that effect?
If that was the target of the challenge that was being brought, and it was properly looked at in that context, and the court's proper conclusion, then yes, of course, that could follow. But the difficulty is in that happening when all that somebody is saying is that I can no longer be on bail. if the automatic consequence of that is that you must be granted leave, then there is a problem with that, because it's out with the statutory contemplation that the grant of leave is a separate concept when the Secretary of State decides whether or not you should have permission to be there. And the last reason is that if you take all of the appellant's arguments together, you end up with an absurd result. The argument is that anyone who cannot lawfully be detained cannot lawfully be granted bail. So as soon as you reach the Hardiel Singh detention limit, you cannot be granted, you cannot either be detained or be granted bail. And then if you couple this with ground 4, you must immediately be granted leave to remain. And we say that that consequence would collapse the whole system into 2 categories only, which is either people who are actually detainable or people who must be granted leave. And we say that the statute simply does not contemplate that, and it would make the Schedule 10 immigration bail system pretty much either unworkable or almost redundant.
But that would be if the appellant succeeded on ground 1 and ground 4.
Yes.
But they also have an argument on ground 2 and ground 4, which is that once you get to a stage where there's no prospect,
yes,
then you can't be bailed, and at that stage, realistically, you have to be granted.
Yes,
And
well,
that doesn't have the same dramatic consequences.
No, that doesn't. But I'm addressing the way that learned friend clarified that she put it, which is ground 4 is really part of ground 1. And if you put those together, you get this absurd result. It's not necessary anyway, and that there's no problem with there being a gap. And as I said, we've always recognised that the gap is not something that you can really be in indefinitely. That doesn't work, and the courts have recognised that.
Well, does there inevitably come a stage where someone has an overwhelming Article 8 case?
If they are here, they cannot be removed. Then there's no prospect of removal. Well, I mean, one should never say never, but we accept that there comes a time when you can't leave somebody in a position like that forever.
Right.
Can I just spend the last few minutes on ground 2? We have set all of this out very clearly in our skeleton argument. I need to deal first with the application about further evidence.
Yes.
We don't object to the court knowing what's happened as a matter of history. We've said that in correspondence. But as a formal application to adduce further evidence, it's irrelevant to the issues that the court has to decide. The judge was deciding the lawfulness of things that had already happened. And this court is to decide whether the judge's decision was wrong. We say that cannot sensibly be based on material that entirely postdates the judge's decision. We accept things have moved on and things are now different. But at the time that the judge was looking at, the question, was there some prospect of removal? It was on the basis of what she had. And it would be erroneous in principle, we say, to overturn that simply because more things have happened since then. This is not a rolling appeal, it's not a rolling judicial review, and it shouldn't be treated like that. We do also make the point that the findings of fact in the FTT are not binding. As a technical sense, there's no res judicata in immigration proceedings. But in any event, we don't accept that there is no prospect of removal, even on the basis of the new evidence. Can I give the court, please, a list of paragraph numbers in the FTT decision, which you can look at if you admit the evidence? It's paragraphs 29, 38, 39, 40, and 42, which together show that the inability to remove him to Guinea is in large part made by himself because he's been frustrating that process. Might that change in the future? Probably a question for another day. but it doesn't mean that there is no prospect, even on the basis of the FTT decision. I've headlined some of the things that we would say on, that we do say on ground 2. First of all, that the judge must have found that there was some prospect of removal in order to dismiss the judicial review claim, and she knew what the law was there, wasn't actually in dispute. But she didn't say so clearly, and so this ground is essentially a reasons challenge to the judge's decision. But there's a problem with the claimant or the appellant mounting a reasons challenge in the way that it has been brought about. First of all, the lack of reasons was a reflection of the relatively light touch way in which the case was argued below. So it's unsurprising that the judge said little about it. The second is that the appellant's application to the judge for permission to appeal didn't clearly set out that this was to be a proposed ground of appeal. If he had done, we might have got more reasons from the judge in response to the application. But if you look at the application for permission to appeal, it just doesn't say anything about that. So, so it's unsurprising that there were no further reasons. The third point is that there is an established procedure where the real complaint is that the judge hasn't given proper reasons, and that's English and Emery-Reinbold. We actually raised this in correspondence, but the appellant didn't take up the opportunity to say to the judge, I've got an English and Emery-Reinbold point, please will you explain what you made on this, so that we can see whether or not we have a ground of appeal. There's a real point to that procedure, but the applicant didn't do so. So the judge was deprived of the opportunity of amplifying her reasons on that basis. We also observed that even when the appellant applied to this court for permission to appeal, ground 2, what's now ground 2, was not in the original application. And it's only because we've prodded that it's been put in, and so technically I think there's an application for permission to amend the grounds of appeal, and secondly an application for permission to appeal on ground 2. We don't object to the application to amend, but we say the application for permission should be refused because there's no merit in it for these reasons. And the reasons are these. It's now too late. English and Emery-Reinbold, well, it wasn't done. 2, the judge must have formed the view that there was some prospect of removal, and she could properly have reached that view because of the factual matters, including those she set out at paragraph 11, i.e. what had recently happened before the hearing before her. And so there is no proper basis for granting permission to appeal on prospects grounds, and it's a case-specific thing, so there's no compelling reason to grant permission for that reason either. Alternatively, an appeal would be unmeritorious for these reasons. First of all, English and Emery-Reinbold. Secondly, the judge must have found that there was some prospect. The third thing, and this is why I asked the court to look at the facts of Gardy and Wes and Kadir. You don't need very much to get over the some prospect hurdle. And so on the basis of what the judge had before her, it was proper for her to find that there was some prospect, or that was the only conclusion open to her in any event. She couldn't properly have said there was no prospect of removal given what had been happening. If we had a new argument on the basis of all the evidence today, the argument would be different, the conclusion may or may not be the same, but for the purpose of an appeal, we say that ground 2 should be dismissed for any or all of those reasons. Lord, I'm sorry that was a bit compressed, but I hope that's explained the position.
Thank you. May I just check if my lords have any? Thank you. No, thank you very much. Yes, Ms. Harrison.
My Lords, can I just deal very briefly with ground 2? It's not correct that we didn't seek permission to appeal from this court on ground 2. That's 17, paragraph 2. It's set out expressly and clearly that we sought permission to appeal on the basis that in the alternative there was no prospect, and we fell within the Secretary of State's definition of liable to be detained on the Kadir approach. So it is fairly properly before the court. We only sought, we only made the application because the Secretary of State made the submission that we hadn't advanced it the ground below. And so that's why we had the application to cover the position. But ultimately, as we said yesterday, and which my learned friend hasn't properly grappled with, is that this is a question based on interests of justice and the overriding objective. You can look at those paragraphs that my learned friend has said. We say it's quite plain from the from the First Tier Tribunal's judgment that it has concluded, as the Secretary, that this man is from Guinea. He's not Ghanaian. So the only possibility that the Secretary of State advanced below, very belatedly, was we could remove him to Ghana. That was the sole basis upon which the Secretary of State said there is now some prospect of removal, having not been able to remove this man to Guinea for the previous 10 years or so, and having taken no proactive steps to even attempt to do so since 2016. So once it's concluded that he was in fact of Guinean nationality, which is what the FTT has concluded, there is therefore no basis whatsoever for the Secretary of State to assert any prospect of removal. And in those circumstances, given that the matter has been fully argued before the court, it was fully canvassed below, as you will have seen from the transcripts, that the interests of justice point strongly in favour of this court now resolving this matter for this man. It's been hanging over him for far too long. And we do say in that context, in respect of ground 3, as my learned friend Ms. Stavinsky indicated, we do say on the facts of this case, the length of time that he has been subject to restrictions and or to bail is far too long. It's 11 years. And we contrast that with Mr. Kadir. You will have seen the sequence of the time frame. He arrived in the United Kingdom in September 2002, and his judicial review, in September 2000, and his judicial review was July 2002. So less than 2 years. So yes, when we look at the Secretary of State's acceptance that there comes a time at which it has to be, there's no other option, but to recognise that you must grant some form of leave to an individual in these circumstances, this must surely be it. A whole decade subject to restrictions on his liberty and no prospect of any change at all in the future. And so we do say that if it's only a discretionary matter, on any view, this is too long for this man. We do say, and we do respectfully submit, that my learned friend hasn't actually addressed the primary submission that we made about what's the answer when you've reached the point, at whichever stage it is, either Kadir or Hardiel Singh, where in the statute, because is there provision for being simply at large? We say this statute covers the entirety of the Secretary of State's powers, and temporary admission having been abolished, the only options open to the Secretary of State are the 3 left now in these circumstances. If they can detain, they can exercise that power. If they can't, it's bail. And once they can no longer exercise the bail power, there is only the provision in Section 3 for a form of leave. Otherwise, the Secretary of State is claiming some prerogative ability to put this person in an outlaw state, no status whatsoever. And we respectfully submit that that can't be right, and my learned friend didn't properly address that issue.
If they granted some form of leave, as you submit they must, could they then, obviously, first of all, they'd have to revoke the deportation order.
Yes, they'd have to revoke the deportation order.
But could they then say, well, actually, we do want to deport you in principle. So would they ever be able to make a deportation order?
In those category of cases dealt with by a case called George, which we haven't looked at in the Supreme Court, where a deportation order was properly made, but was subsequently, as a result of an appeal on Article 8 grounds, successful, so it had to be revoked. That person was given limited leave. There was an argument before the Supreme Court that because this man had previously had indefinite leave to remain, it needed to revert to indefinite leave to remain. The court said, no, it must be limited. It can be limited leave on the basis of the statute. But it wasn't possible to leave that person with no status whatsoever. That is not a proposition that the Secretary of State has advanced in any other context. George is in tab 46 if your lordships wish to look at it. And even in that context, it was recognised, I think, by Lady Hale that there will come a time at which you will also have to give that person indefinite leave to remain if they can't actually be removed, even if, of course, the Secretary of State remains of the view that it's not conducive to the public good to do so. The law does recognise that these forms of indeterminate status need to come to an end so that the person can live in society in an ordinary way. And that obligation, in fact, has become even more acute in circumstances where the Secretary of State, the Parliament has created what's called a hostile environment, because that's an environment that's intended to to exclude the person in practical terms from any notion of an ordinary existence, renting a property, working, access to certain forms of healthcare, private accommodation. So the obligation to bring to an end that circumstance has certainly increased since the Kadir time because of the consequences. It was recognised by the House of Lords in Kadir that it may be harsh for Mr. Kadir to be on temporary admission with those restrictions. Now he would be in a much more severely curtailed state of existence because of the changes that have been made in the law since 2014, 2016. And that needs to be taken into account. And in fact, when you look at the judgment of the upper tribunal in the case of AM, which is tab 60-105, that is a factor that the upper tribunal had reference to in concluding in that case that if it found that there was no longer any power to impose bail, the only option would be to grant leave. So we would invite the court to look at paragraph 105 of that judgment. So, my lords, that's dealing with 3, 4 and 2. Obviously, what's important, and I'm slightly short for time now, is 1.
Well, don't worry, if you need to go slightly beyond 1 o'clock, then you must have that time.
I'm grateful, thank you. So, we look at paragraph 10, 9 and 10, 12 at the end, because it logically comes at the end of the statutory provisions. However, I sought to show the court how the regime that was created under Schedule 2 is in the classic form of a bail regime. The person's liberty and the circumstances in which they exist are contingent upon compliance with the conditions that are imposed. And there must always be at least one condition. And those were the paragraphs that I showed you at 10.2.1, 10.2.11, and 10.3.1b. All of them do what the Supreme Court in B understood bail to be, applying on cases like Stellato. It is a conditional form of release. It's not true liberty. The significance of that is that that is, in fact, the way in which one has to look at this statute as a whole. Because it does that, because it makes your liberty contingent on compliance with conditions and provides in 10.1 for a power of arrest if you breach them and 10.2 for a power to detain you, pending being brought before a court to decide whether or not you have breached your conditions, this provision plainly is a provision that is about detention. And we respectfully submit that that therefore means that all the approach that we advanced yesterday, strict, narrow, looking for the clearest possible words, are plainly the overriding statutory canon of instruction that needs to be construction that needs to be applied. And that cannot be sidestepped in the context of 10.9, because if the person has breached bail, there isn't the option in the statute to say, well, we're not going to bother to arrest them and detain them. And we couldn't assume that that's what would happen in a case where the person couldn't be lawfully detained, like my client in Hardiel Singh principles. We have to proceed upon the basis that that's what would happen. And there is no answer. The answer that was given by the judge below and repeated by Mr. Tam to the court in the 10.12, well, we don't have to order your re-detention or continue your detention. You can simply be put on bail. That can't arise in the 9 situation because you've already been detained, and you've been detained as long as it's reasonably practicable to get you before a court. And it is significant that it is no longer just 24 hours, although 24 hours the point would still arise. We don't know how long that's going to take. Presumably, Parliament removed that restriction because it recognised that sometimes it can't get people there for 24 hours, and that's an administrative problem. That therefore means this statute authorises actual imprisonment for breach of bail for a duration that is curtailed only by the broad words reasonably practicable.
Why does this arise in this case? I mean, if somebody were in that situation, they were detained under 10.9, they might or they might not have an argument, for example, that this was a breach of the Human Rights Act. But why does it bear on the question of interpretation we have to decide?
Because it's critically important to the interpretation. This is a statutory scheme that is predicated on the conditions being backed up by the power to detain you. So you're having to construe them on that basis. And it expressly says in 10.12 the phrase liable to be detained. It can't possibly be interpreted as meaning simply the cadir, no prospect. Liable to be detained in that context must be interpreted as lawful detention. Because as we know, and Mr. Tam didn't contend for the contrary, it's not paragraphs 10.1, 9 to 12 that confer the power to detain in those circumstances. They're only referable back to the underlying statutory provisions to detain in Schedule 2 and Schedule 3.
Well, that may be true of subparagraph 12. I'm not sure that's necessarily true of subparagraph 9.
It doesn't matter in this way, because if that were to be the case, one, the consequence of that is that this statute creates a brand new power to detain that wasn't there before. So that will impact on the court's approach to statutory interpretation. Secondly, it cannot be a lawful power to detain in the context of Article 5(1)(f), because I have to say to my learned friend that the use of the phrase border control obviously has nothing to do with the way in which, with the words that are used in 5(1)(f). It's examination or with a view to deportation. And I showed you the case, I referred to the cases yesterday. Mr. Tam hasn't said anything to the contrary. With a view to deportation means exactly the same as the Hardiel Singh principles. So you would be providing for a power to detain for breach of bail in the immigration context, if that was correct. And it wouldn't be compatible with Article 5(1)(f). It just wouldn't be. Learned friend made submissions yesterday in her skeleton argument and in our skeleton argument as well. It doesn't fall within 5(1)(f), and they're exhaustive. It doesn't fall with any one of the other categories. It stands or falls on being able to be connected to the underlying immigration powers to remove, and they can't be operated lawfully they can't be operated in a case where there's no realistic prospect within a reasonable period of time. So we have to deal fairly and squarely with the fact of what this statute actually does. And the importance for my client is that up until the 5th of January 2018, he wasn't in that situation because he was released on restrictions under 325. So there was no power to re-detain him if he breached his conditions. That was a fundamental change in his status. It made his liberty contingent upon complying in a way that it wasn't immediately before the coming into force of the Act. That's a radical change in somebody's, in the relationship between the power of the state and the individual, which is also why we respectfully submit the strict interpretation required from B, clearest possible words, applies in my client's case as it does in every case, even if the only conditions that are imposed are a single condition of residence or a single condition of reporting.
So if you'd breached his conditions attached to the restrictions,
Yes, he could be
before-
prosecuted, but
so
not,
that would
not
have been
re-detained.
so the only sanction available would have been prosecution.
Yes, yes, yes. And obviously that was because the contrast, bail has this ongoing close correlation and connection to the underlying power to detain that isn't there if you've been released on restrictions. And so we respectfully submit that the approach of saying, well, it might not, it doesn't immediately arise in this case, or you have some other remedy, is not an answer to a case which is about the construction of a statutory scheme, where these are, on the face of the legislation, the implications of the introduction of this scheme and the application of it to my client. Similarly, we say when it comes to Article 5, and there is no answer to the 10.9 and 10.12 point because they provide for detention. But also, the fact that these provisions in Schedule 10.2 and 10.4 provide for a form of the potential for deprivation of liberty, even if there is no deprivation of liberty in this particular case, the court has to deal with that head on and take that into account when it comes to its interpretive obligations. That's what the Supreme Court in B said they were going to do, and that's why, although it was about bail and not detention, they adopted the same canons of construction from all those lines of cases that we're familiar with, Tanti, Lam, Kawaja, strictly construed, clearest possible words, the court jealously guarding the liberty of the subject. And that applied even though Mr. B was not in deprivation of liberty territory. And what would have to be confronted, if the alternative were the case, is that this is a overbroad power. It couldn't just be left there on the statute book for somebody to be detained and then have a reactive, retrospective remedy. We know that, obviously, from cases like Lumber, citing the well-known Strasbourg case of Gillen. If the power is overbroad and it covers categories of cases that shouldn't be there, it's going to fall foul of the of Article 5 or 8. And the answer is not to say, well, bring a claim for false imprisonment or judicial review. The answer is for the court to use Section 3 of the Human Rights Act and read down, where it can, that legislation. And what we're seeking for here is to imply into liable to be detained, lawfully detained. The Secretary of State reads in to liable to be detained where there's a lawful existence of a power. We're seeking to extend it to the post-Anasminic standard, now recognised form of illegality, which goes beyond whether there's jurisdiction and the existence of the power, but where it cannot be lawfully exercised compatibly with those core Hardiel Singh principles. And that, we respectfully submit, would have to be the consequence if we were right about the way in which this legislation is incompatible with Article 5.1f. It is equally incompatible with Article 5.4, because if tomorrow my client is detained because he oversleeps and he fails to attend on the reporting, or he's unwell and he doesn't go, and the immigration officer, overzealous, immediately goes for an arrest warrant. If I went for habeas corpus in those circumstances, or now more likely judicial review, what would be the answer? On the Secretary of State's case, the only answer is he's put back on bail. And my learned friend seeks to suggest that the Court of Appeal in B, paragraph 33, is somehow per incuriam. He made the same arguments to the Court of Appeal in terms of the significance of the two cases that have been relied on by the Court of Appeal, and they were rejected. We've provided you with copies of contemporary extradition cases that make it plain that the approach from the case of Armand is what is standardly applied in that context. I'd ask you in particular to look at the case of Launder, a decision of the Divisional Court. Lord Justice Simon Brown, as he then was, at paragraphs, it's between 1000 H and 1001 C. And in the judgment of Lord Mr. Justice Mant, as he then was, at paragraphs 101 C to H, they're sidelined. That's one case, following and applying the approach of the House of Lords in Armand to an extradition case where the person had been on bail, but nevertheless the writ of habeas corpus was still issued. And the fact that the remedy of habeas corpus isn't what we use now doesn't mean that its principles aren't integral now to judicial review. It's practicality, not the core common law principles that those cases, that remedy is provided. And it is absolutely clear that bail is not a remedy for illegality, whether one is looking at habeas corpus or judicial review. And the Supreme Court in B has put that beyond argument, although Mr. Tam seeks to resurrect the very same arguments that he did before that court. And it's important to recognise that the Supreme Court, although we had the cases that my learned friend refers to and many more, looking at the ancient provision, preferred to put its judgment on current and contemporary case law to similar effect. And your lordships will see that at paragraphs 48 to 51. Citing Stellato, citing Conan, citing WL Congo, all for the same proposition. Bail is not a remedy if you are unlawfully detained, either at common law or under Article 5.4, and for the very reason that it is contingent liberty. It's not true liberty, it's conditional. And it's that that defines bail, it's that that distinguishes it from temporary admission, and it's that that means that this court cannot do what my learned friend suggests, and the learned judge did below, which is to choose a form of statutory construction which is based on history and inference from history, instead of those core principles of statutory construction based on the court setting its face without the clearest possible words against intrusion on liberty, where it interferes with fundamental human rights. Legality is firmly in play here, if only for the reasons of 9.10 and 10.12. it also overrides protections of the common law, including the remedy of habeas corpus, if bail is the only option when you're unlawfully detained, and authorises an imprisonment. The learned friend accepts that. The case of Jallow, he agrees. And paragraph 10.4, which provides for curfews, provides for an imprisonment under the common law. Obviously, it would be a lawful imprisonment if the provisions are now made, but as a matter of fact, it will be an imprisonment if you're subject to a curfew. And again, and it was an important part of the changes that were brought about this legislation, in effect, to also reverse Jallow, because previously you could not put a person who was on temporary admission or temporary restrictions in a situation of imprisonment through a curfew. Supreme Court ruling to that effect. However, once those individuals who had previously been on temporary admission overnight then became subject to bail on the January 15th, 2018, could then lawfully be subject to conditions that constitute an imprisonment of common law. That's a further reason why we respectfully submit there is no way out of recognising this legislation on its face is a very substantial intrusion, and indeed provides for a form of detention, at least at common law. And again, why it is we respectfully submit that those forms of interpretive obligations should have and must override the approach that was taken by the judge below. We do say that they do rest too much on what did Parliament wish or hope or intend to achieve, as opposed to what they actually did achieve. What's the legal meaning of those words, and particularly when construed with that strict and narrow construction that's necessary given the impact of this legislation. And my lords, can I then just take you back to the key paragraph that my learned friend relies on, and it's section 61, and then its implementation, if it is that, in section in schedule 10.1.5. It is important, as the court recognised, that section 61.3 dealt with cases where the person was being released. So it dealt with cases where where bail had been, where the person had been detained and were then released, and that's different from section that's different from paragraph 1.5. So we say, and we do submit, that if what Parliament intended to do in section 61 was to reverse the judgment of the Court of Appeal in B, it would have said lawfully, can no longer be lawfully detained. That would have been the most straightforward, simplest route to do so. It would have meant then that Parliament would have confronted the fact that it was making a substantial change to common law protections and making people liable to conditional bail when the law previously hadn't recognised that. And it would have addressed the modification to habeas corpus, and it would have addressed the problems of compatibility with Article 5.1f and Article 5.4. Parliament did not use lawful detention, liable to lawful detention, and it did not confront all of those consequences. And for that reason, we respectfully submit that the approach of the Supreme Court in Privacy International directly bears over to this situation, recognising, of course, the court's particular care that approach to ouster cases. But the reasoning at 111 that we was shown yesterday directly applies to this situation. And the repeal of that, it cannot simply be said, as my learned friend seeks to do, that section 61(3) is simply read into the statute in Schedule 1.5, because Schedule 1.5 does something very different, because it now applies not to those who have been detained or have ever been on bail. It applies to those who are on temporary admission or temporary restrictions. And it had to make some express provision to deal with that category of person, because that is a very substantial change in their circumstances, because it makes them not only subject to more intrusive conditions, it also makes them liable to be detained if they breach those conditions in circumstances where they may have spent many years simply on temporary admission, complying, waiting for their claim to be decided.
I think we understand that.
But it's important, because that's what you need to understand the purpose of.
I've no doubt it's important, Ms. Harrison, but we are at 1:05 now.
Yes. Well, if I can just conclude it this way, which is our interpretation of that is that that's what 1.5 does. It makes it clear that you can apply bail to people who have never been detained and there's never been any need for bail to be imposed.
Yes.
And that is a plausible alternative. Applying the canons of construction, if the court accepts that, then we respectfully submit that provides the answer to the weight that's put on Schedule 1.5 by 10.1.5 by the Secretary of State. And we do adopt the submission, which I don't think it was properly addressed by my learned friend, is that if he's right, for the category of case that we're concerned with, those who can't be lawfully detained, why isn't 1.2 sufficient? Because it says liable to detention, meaning obviously and clearly Kadir on his interpretation. Why do you need 1.5? It's 1.5 that's OTOs if you look at 1 and 2 together, because it's 1.2 that provides for the Kadir limitation on the detention, and so 1.5 must be doing something different. It's also important to recognise that my learned friend is accepting that 1 and 1.2 are not sufficient to get him home, because you can imply into 1.2 lawfully detained. And so if we've given you a plausible explanation for why Parliament needed to expressly address the situation of those who hadn't been detained or on bail, as we have done in 1.5, then on his own analysis, 1.2 isn't sufficient. And just finally on Kadir, the paragraph of Lord Dyson's judgment at 34, which Mr. Tam read you, or referred to, he didn't read the final part of paragraph 34, but what paragraph 34 does is Lord Dyson saying, if Kadir is to be read into the bail power, I don't agree with him. And so it's not settled authority in the context of bail. I think there's one other argument that I do have to deal with that I haven't yet. If you could just give me that indulgence, it's section 67. It's important to note that my learned friend did not rely upon section 67 below. And there's very good reason why he didn't. I'm not going to take a point that he would need a respondent's notice, but I am going to say there is a very good reason. And it is because section 67 has those words in it, which is that it is not about any provision that is concerned with the power to detain. And for reasons that I developed in the context of ground 1 relating to paragraphs 10.9 and 10.12, this is a provision that deals with detention. Just as the Supreme Court in B recognised that the approach to bail also involves detention because it's contingent liberty backed up by the ability to detain. In that broad sense, we do obviously also have in 10.1, 9 and 12 the actual power to detain if you are thought to be breaching. So in those circumstances, Section 67 is not the answer for this case. And my learned friend was quite right and proper not to have advanced it as such below, and this court ought not to entertain that possibility as being the solution to this case. Right. And we would still be saying, for all the reasons that we've argued in terms of construction, that liable to detain, when it comes to the conditions of bail, would still have to be interpreted by reading in lawful detention. And my lords, for those reasons, we ask you to grant the case on ground 1, alternatively on ground 2. And if you do so, then to declare that the Secretary of State should grant this man leave to remain in the United Kingdom, albeit on a temporary basis. Right. Lords, those are my submissions in reply.
Thank you very much.
And thank you for the additional time.
Thank you. We have one outstanding procedural step. Mr. Tam, what I'd like you to do is to, if possible, in agreement with Ms. Harrison, to file a short note, and I do stress short note, which helps us to understand both the legal regimes which applied at all times since January 2011, under which these restrictions are imposed on this appellant, and if there are any factual documents like the restriction notice, then those can be supplied to us along with that. How long will you need to do that?
I think it would be safest to ask for a week, if you may.
All right. Yeah.
What I have in mind is a document extraction may take longer than just a purely legal one.
I understand. Yeah. Well,
this is a factual note, not an opportunity for further submissions.
Yes. We stress that this is not an opportunity to make further submissions on either side.
Entirely understood. Yes.
What I can do is, from our files, we've found what we think are all the relevant
documents.
Well,
rather than take,
and I'll give those to my
don't take time now because I've got another commitment to get
sorry.
to. But if you can agree that between yourselves and file it within 7 days of today's date, all right. But all that remains for me to say is to thank everyone for their submissions. We will, of course, take time to consider our judgments, and they will be circulated in the normal way in draft on a confidential basis. And we envisage that if there are any outstanding issues, they can be dealt with without the need for further hearing. And indeed, in accordance with modern practice, it's intended that the judgment itself will be handed down without any hearing, not even a remote hearing. Unless there's anything else. Thank you all very much.
It wasn't that anyway.